For reasons mentioned in the judgment, this criminal petition is dismissed.
Much obliged.
May it please your Honor. I beg to mention item number 52 of the supplementary list. Yesterday I have been informed by the learned counsel for the respondent that the respondent number 2 has expired, my lord. And I have received the name of the, my lord, representatives. So I'll have to substitute this, my lord.
You have informed the other side.
Yes, yesterday.
Heard Mr. R. Goswami, learned counsel for the petitioner, who submits that he has been informed that respondent number 2 has expired, and accordingly he has to take steps for substitution of the legal heirs of the respondent number 2 and seeks some time for the same. The prayer is allowed.
Obliged.
List this matter after 2 weeks.
Obliged.
May I please your lordship? Lordship, I beg to mention for listing of a CRP IO, your lordship, which was last filed on 26/9/2025. It has been already been numbered, your lordship. There is urgency. Maybe on 22nd, your lordship.
Okay.
22nd.
Maybe, Worship, I'm saying if you adjournment, my lord, item number 11, my lord,
Item number
11, my lord.
11.
My similar is other question, my lord.
Heard Mr. What is your name?
Hussain.
Heard Mr. A. Hussain, who prays for an adjournment on the ground that the conducting counsel for the petitioner is out of station. The prayer is allowed. Considering the submissions made by learned counsel, the prayer is allowed. List accordingly on a date to be fixed by registry.
Obliged, my lord.
Lordship, I beg to mention 2 items for listing, Lordship, after Diwali. For in the orders column, Lordship.
Okay.
May it please your lordship. Lordship, I beg to mention item numbers 9 and 10 of the daily list, lordship. Lordship, conducting counsel, Mr. Arbor Pujari is not well, lordship. I pray for adjournment, lordship.
Heard Mr. P. Burwa,
Miss Arbor.
R. Burwa, learned counsel for the petitioner, who prays for an adjournment on the ground that conducting counsel for the petitioner, Mr. R. Pujari, is indisposed. Stop. Considering the submissions made by learned counsel, the prayer is allowed.
Can be listed next week if possible.
Let this case be listed in the next week on a date to be fixed by registry.
Your Honor, I beg to mention item number 21 of the daily list, Your Honor. I am for the respondent. My senior is not well, Your Honor. I have taken the consent of the other side.
What is your name?
M. Das, Your Honor. And Your
Heard Miss M. Das, learned counsel for the respondent, who prays for an adjournment on the ground that conducting counsel for the respondent is indisposed. She submits that she has informed learned counsel for the appellant regarding her prayer for adjournment, who has no objection to the same. Hence, the prayer is allowed.
Honor, one more prayer is that, Your Honor, my name of the conducting counsel is not reflected in the cause.
What is the name?
Mr. Avinash Kumar Roy. His name may be reflected.
Stop. Let the name of Mr. Avinash Kumar Roy be reflected as engaged counsel for respondent number,
So respondent.
for engaged counsel for the sole respondent in the cause list henceforth.
Your lordship, I beg to mention item number 20. There is some personal difficulties on the petitioner advocate. Kindly the matter may be adjourned for the day.
20.
20.
What is your name?
S. Kathak, lordship.
S. S.
S. Kathak, lordship.
S. Kathar, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Prayer is allowed.
May I please, your honor? Your honor, item number 49, your honor. Kindly adjournment the matter for the day. My senior is out of season.
What is your name? What is
Mr. T. Uddin.
heard Mr. T. Hussain, Tiuddin, learned counsel for the applicant who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the applicant, considering the ground shown by the learned counsel, the prayer is allowed.
May it please your lordship, I beg to mention item number 32. It is listed in the orders column on behalf of my senior VD Rekha. The consent has been taken from the other side, your lordship. It may be kindly adjourned for the day.
Item number 32,
Yes, your lordship.
heard Miss, what is her name?
B. Paul.
B. Paul,
Yes.
learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner, Mr. B.D. Dekar. She submits that she has informed the learned counsel for respondent regarding her prayer for adjournment, who has no objection to her prayer. Stop, hence the prayer is allowed.
But prayer, your lordship, if the matter may be listed after 4 weeks,
Let the matter be listed after 4 weeks on a date to be fixed by registry.
much obliged, your lordship.
To be spoken to item 2 and 3.
I don't have any questions.
Yes.
I am fixing it for delivery of judgment on 23rd
Of this,
of this month.
deeply of this.
Yeah.
Deeply.
Heard Mr. D. Das, learned senior counsel, assisted by Mr. S. Dekar, learned counsel for the appellant. Also heard Mr. D. Majumdar, learned additional advocate general, assisted by Miss D. D. Bormon, learned senior and learned additional senior government counsel appearing for state respondent. Also heard Mr. M. Nath, learned senior counsel assisted by Mr. A. Bhattacharjee, learned counsel for respondent number 2. Let this case be listed for delivery of judgment on 24th of October.
Deeply of this.
Moves on, item number 5.
Lordship, Mr. Sharma is in legs before another court. May kindly pass over the matter for the time.
Okay, we'll take it up after some time. Let him come.
My lord, this application under section 115 of the CPC, my lord, for revision. My lord, the respondent plaintiff filed a suit before the trial court, my lord, for the ejectment and recovery of the area rent, my lord.
You put on your microphone.
My lord.
Yes,
My lord, the respondent plaintiff, my lord, filed a suit, my lord, before the trial court, my lord, for ejectment and recovery of the area rent, my lord. Now, our plea in this revision petition, my lord, is that, my lord.
you are tenant.
Yes, my lord, I am the tenant, man.
Yes.
I am the tenant, my lord. As per the, my lord,
The suit was decreed.
it was decreed, my lord. Same appeal was filed.
Appeal was dismissed.
Appeal also dismissed, my lord. The order of the judgment and degree of the trial court is upheld, my lord, with slight modification, my lord. And this against this, my lord, appeal, my lord, this revision is preferred, my lord. Basically 2 or 3 questions, my lord. One thing is that, my lord, the suit land, my lord, where the alleged building was situated, my lord, that is a government land, my lord. Our basic point is that when the government is not making a party, this is the non-gender of necessary party, my lord. And the second thing is that, my lord, the finding of this court
as well as the appellant court as well as the trial court is that we are the defaulter in payment of the rent, my lord. Whereas, my lord, we are continuously, my lord, depositing the rent in the by way of NG case, filing a NG case in the Munship number 4, my lord. We regularly depositing the
What
rent,
was held by the trial court
my lord.
in this aspect? What was the observation of the trial?
My lord, observation is that, my lord, there is a two contradictory observation. My lord. Once, my lord, the landed court below admitted that I am depositing the rent, my lord. Another thing is that, my lord, I am in defaulter in payment of the rent, my lord. Because, my lord, there is one thing happened, my lord. During the trial, my lord, we prayed to exhibit the record of the NJ case, my lord, it was in later stage, my lord. This was rejected, my lord. In the appeal also, my lord, we file an application under order 41, rule 27, my lord, to exhibit the record of the NG case, my lord. That was also not allowed, my lord. My lord, on the based upon that, we found that we are a defaulter, my lord, in payment of the rent, my lord. Lordship, as this said also, you should notice, my lord, and call for the record.
Heard Mr. K. M. Hassan, learned counsel for the petitioner. This application under section 115 of the Code of Civil Procedure 1908 has been filed by the petitioner Shri Dinesh Sarkar, impugning the judgment and decree dated 14/8/2025 passed by learned Civil Judge Senior Division number 1, Kamrup Metro, in title appeal number 19/2022, whereby the judgment and decree passed by the learned Civil Judge Junior Division number 2, Kamrup Metro, was upheld. Issue notice to the respondent and call for the case record of title suit number 162/2015, as well as that of title appeal number 19/2022 from the concerned courts. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
That's all.
May please the lordship. Well, Lord, this revision petition is directed against the judgment of the judgment dated 18/6/2025 by the first appellate court. As there is no provision of second appeal, we have to approve this now court in division. Well, Lord, here in this case, the
This
petitioner.
is a suit between tenant and landlord.
Yes, my lord. He is a tenant having a rented house from the defendant for running a business, a hotel business, namely missing pieces. And the term was initially 3 years, and there was a
The trial court,
Understanding-
you were the defendant.
my lord, the trial court has issued frame. Evidence was submitted, but no cross-examination. Without cross-examining the witnesses and on the preliminary issue. Instead of the issue frame, decided the case.
And the first
dismissed.
appellate court,
First appellate court also dismissed the appeal, and first appellate court has held that there is bona fide requirement of the tenant, the defendant, and the finding fault on the petitioner that she approached the court.
on what ground you have preferred revision? What is your
We
ground?
have approached on the ground that the view taken that the section 5(4) of the Assam Urban Area Rent Control Act 1975 was not
it was not exhausted is not correct because the petitioner approached the defendant and not considered. Then the bona fide requirement, on the point of bona fide requirement, the defendant has son, he employed son, two employed son, and wife is also employed. They are staying in Bangalore. So bona fide requirement is totally missing in the case. Then the evidence, which issues framed but decided the tribunal, the first appellate court on preliminary issue, and the appellate court also ignored this point. And without cross-examining the witnesses, they decided the case on preliminary issue. Then, and one point is that the first appellate court.
Yes, you have anything to say?
So, Lordship, I am for the caveator. Lordship, the tenancy agreement was entered for the period 1/8/24 to 31/7/27, Lordship, 2017. Lordship, kindly come to their petition, plain Lordship, prayer, page number 21, Lordship. 21. Prayer person, Lordship, in number 3. At the, Lordship, get it?
Yes.
Prayer number 3, a decree directing the defendant to extend to the tenancy of scheduled room in favor of the plaintiff for a period of 6 years, with effect from 1/8/2017, Lordship. And during pendency of the suit, Lordship, the 6 years already elapsed, Lordship. So, Lordship, on our prayer, the court framed the preliminary issue regarding maintainability of the suit and satisfied that the already 6 years period is already over. So the plaintiff has no right to the occupied the suit position, suit premises, Lordship. And same thing also reflected in the order, Lordship. And let's see the order, Lordship. Page 43, Lordship. The order passed by the civil judge 1, Lordship. Relevant para 6, Lordship. Their prayer was to extend the tenancy agreement period, Lordship, for 6 years. And 6 years already, Lordship, passed. Order was passed in the year 2024, Lordship.
Lordship, may kindly have a look at page 45 also. This is another order passed by the trial court, civil judge senior division. The trial court has admitted the own fault.
Yes, Lordship, this was, I have filed a counter claim, Lordship. That was also dismissed.
So it is dismissed.
This was also dismissed along with the title suit, Lordship. So the caveator filed a petition on his prayer, Lordship. The counter claim is proceeded for proceeding, Lordship. And now this case is pending for
Counter
PW.
claim for recovery of area.
Yes, Lordship. And now this same is pending for PW evidence, Lordship. We have filed the evidence already. Their prayer was, Lordship, to extend the tenancy period for 6 years, Lordship.
Yes, what is the, where is the error?
I have no other place for running my business unless I can run my business.
No, but your tenancy is not there. The tenancy
They are on
term.
understanding that they will extend the
And also
period.
they're
Subsequently
filing
taken a
case,
stand
Lordship, one by another
not
case,
to
Lordship.
extend. We are pursuing the defendant, my lord, landlord, to extend, to consider extension, but that has been.
And the same is bona fide required, Lordship. The petition,
Bona fide
caveators
requirement
on
is absolutely baseless.
engineers, we have submitted the registration of the farm, Lordship. The petitioners sons, they're supposed to start their business, Lordship, in the tenant premises. And that was also filed before the trial court, Lordship. And this fact
In
also,
this revision petition, what is your ground? We cannot go into evidence.
Lordship.
We cannot.
Evidence was not taken, evidence in chief submitted, not cross-examined. Before examining the witnesses, the proceeding has been closed
On preliminary issue,
Yes,
on
Lordship.
preliminary issue.
okay, we'll examine that. Whether any execution case has been filed.
No, Lordship. The counterclaim is still pending. Your Honor.
Heard Mr. A.R. Sikdar, learned counsel for the petitioner. Also heard Miss, what is your name?
P. Sohoria, Lordship.
P. Sauria, learned counsel for the aviator slash respondent. This application under section 115 of the Code of Civil Procedure has been filed by the petitioner impugning the judgment and order dated 18/6/2025, passed in title appeal number 19/2024 by the Court of London District Judge, Kamrup Metro, whereby the said appeal was dismissed and the judgment and decree passed by London Civil Judge Senior Division number 1, Kamrup Metro on 22/3/2022, passed in title suit number 196/2017, was upheld. Since the cavator has appeared, no formal notice need to be issued to the respondent. You have received
Yes,
the-
Lordship. I have received the copy.
Stop. Let the records of title appeal number, let the original record of title appeal number 19/2024 be called for from the Court of London District Judge, Kamrup Metro. Let also the scanned copy of the records of title suit number 196/2017 be called for from the Court of London Civil Judge Senior Division number 1, Kamrup Metro. Let this case be listed again after receipt of the aforesaid records on 13th November. 13th November.
No, Lordship, interim order cannot.
No interim, they have
Yes,
not yet filed any execution case.
Obliged.
May I please the loss? My lord, the impugn order, my lord, is at case 124, my lord. 124. The issue, my lord, here, my lord, whether the provision of CPC will apply, my lord, in the case.
Interim order is, impugn order is at page 124.
124.
What is this order?
In this case, my lord, the respondent number 2 was appointed as arbitrator by respondent number 1 to execute an agreement of 2019. The agreement was, my lord, challenged in the London Civil Court, and the complainant filed an FIR against me. Dispute regarding, my lord, distribution of share in contextual law. Our claim was that
Distribution of shares
in executing contextual law, my lord.
Okay.
His claim that he has invested money, but his share was not provided to him. So he filed an FIR against me. Then FIR was challenged before this Honorable Court. The Honorable Court stayed the proceeding. Then, my lord, he filed this arbitration proceeding by appointing respondent number 2 as sole arbitrator by himself. Then arbitration proceeding was started. We challenged the proceeding, my lord, in title suit. That was also pending. And as there was no stay in this proceeding, the arbitrator continued, my lord. So we filed a application for, my lord, stay the proceeding. In the said case, my lord, we filed petition, my lord, case 40 in 2004. Then written statement was filed, my lord, after, my lord, 188 days. So we filed objection that written statement should not be accepted because 90 days or 120 days is maximum period. Then, my lord, our condition has been rejected by the impugn order, saying that provision of CPC will not apply. Our condition that CPC or, my lord,
Where is your petition?
our petition, my lord, our objection, my lord.
Your
Yes,
prayer was to not to take written statement on record.
87, my lord.
Page number?
Page 82, my lord. Page 83, paragraph 4, my lord. Here is page 84. So matter may be examined, my lord.
What was held?
Held that, my lord, CPC, there is no bar, my lord, there CPC will not apply, my lord.
Where?
And written statement has been accepted. Page 180,
Read the relevant provision where
page
the
182, my lord.
court held that CPC would. Where it is held that.
In the middle, once the court has fixed an extended time for filing and the
Where,
parties
in which page you are reading?
1 to 8,
Yes, which para?
1, 2, 3, fourth para, my lord.
Yes, read.
Once the court has fixed and extended the date for filing and the party complies, such filing cannot be treated as a time bar. In both the instance, the written objection were filed in accordance with the date fixed or liberty granted by court. Prior to that, my lord, they have taken so many time, my lord.
Where the court has
Page
stated that.
128, my lord, second paragraph. The record shows that, lordship got it.
Yes.
The record shows that in respect of opposite party number 1, 25/11/2024 was date fixed by this court for filing, and the objection was filed accordingly. No doubt he has taken adjournment on so and so. In respect of 1, liberty to file was granted, and the objection was filed on so and so in compliance with the direction. The said party has taken adjournment on so and so. So our objection was that, my lord, after, my lord, 90 days or 120 days, my lord, the objection should not be accepted.
No, but court has given a reason for accepting.
Okay, saying
And
that, my
where
lord,
it has,
on technical
where
ground,
it has stated that CPC would not be applicable.
my lord, 127, discussion, my lord,
Yes.
discussion. So indirectly it was held, my lord.
You are making wrong submission.
India
And
is saying
therefore,
that, my lord,
this,
as my lord,
this revision
provision
petition
not
is liable to be
mandatory.
dismissed on that count only.
Lordship kindly see order dated order.
No. Your revisions, this
Lord.
revision petition is dismissed. I'll write orders in chambers. You cannot afford to make wrong submissions before the court.
My lord,
Otherwise also, this case does not merit any consideration. You go through my order later on. The revision petition is dismissed.
Pending item 5.
Yes, what is it?
So we have approached this honorable court against the order passed by the learned DRT, that is at page 186. What has happened, my lord, was that an OA was filed against the present petitioner. Notice was not served upon the petitioner. If my
No,
lord may
just a minute. Your prayer for condoning
was
the
rejected.
delay was rejected.
Yes, ma'am.
Against that, you have preferred
Yes,
this
this revision.
under 227.
227 I have it. Because the Constitution of India provides, my lord, that every high court shall have juris superintendence over all courts and tribunals throughout the territories in
No,
relation
but
to.
for that you have to show how under 227, we will not exercise appellate jurisdiction,
This is revisional jurisdiction.
supervisory
Yes,
jurisdiction.
supervisory jurisdiction.
So
Why
where is the error?
error, my lord? First of all, notice was not served upon the petitioner. If my lord may kindly peruse page page 111. That is an order of the tribunal on 14/10 to 2020, page 111. The matter is taken up through video conferencing. The case was filed at the time of when the COVID
111.
111.
What is this?
This is a order dated 14/10/2020. The matter is taken up through video conferencing. Learned counsel so and so has appeared for the applicant bank. No one has appeared for defendant 1 and 2. Today, the date was fixed for completion of service and pleadings. The learned counsel for the applicant bank has filed service report and brought on recorded postal receipt along with track consignment report. It is observed from track consignment report that notice has not been served upon the defendants, hence the service is not completed. Hence, the learned counsel for the applicant bank is directed to serve by the defendants by way of paper publication. So they were asked to serve through paper publication. Thereafter, my lord, they had in Times of India and Doinik Assam, it was published on 9 January 2021. My lord may kindly note the period, my lord, 2021, when the COVID pandemic was at its full. Then at that time, the notice was issued in Times of India and Doinik Assam. Thereafter, my lord, we had never received the paper publication nor the notice. We came to know about this case only when a notice was served upon us from the recovery officer. That is the notice dated 11. We had received the notice on 28/8/2024, my lord. The notice is at my lord.
Where?
So after that, we had filed this application before the DRT
When?
for setting aside of the ex parte order.
When have you filed there?
We had filed it on
November 28th of November 2024. We came to know on 28th August 24, and we filed the application on 20th of August 2024.
You came to know on
28th
28
August 2024,
and when you filed the
on
application,
2011-24.
3 months.
3 months. Less than 3 months.
Then
Thereafter, they filed their objection in the delay condonation.
why the tribunal
The
rejected
tribunal, the error of the tribunal is, my lord, may I kindly peruse page 192. The tribunal has in its order has observed, my lord, at the last paragraph at page 192. The only guiding from below 1, 2, 3, 4, fourth line, the only guiding principle to be seen is whether a party acted with reasonable diligence and had not been negligent in the presentation of the matter. Each and every day of delay is to be satisfactorily explained by the petitioner. But in the present case, the applicants have failed to show any sufficient cause for condoning the delay in their application filed for condonation of delay. An application for setting aside of the ex parte judgment.
What was your plea before the tribunal?
My plea before a tribunal, my lord, if my lord may kindly peruse my application under section 5. That is at page 93.
Yes, what was?
We at page 97 is the relevant paragraph. We have written, my lord, from the perusal of the order dated 14/10/2020, it is seen that a direct consignment report that notice was not served upon the defendant applicants herein. It was further observed the service was not complete. The order dated so and so passed by the register of the tribunal indicates that the counsel of the applicant bank was directed to serve the defendants by way of paper publication in 2 widely circulated newspaper, out of which one would be in vernacular language. On 27/11/2020, the matter was taken up through video conferencing by the registrar of this honorable tribunal, where the registrar had placed the matter before the presiding officer of the tribunal. Thereafter, that on 9/12/2020, the counsel of the opposite party bank sought for time for taking steps upon the defendants to paper publication and fresh order for paper publication. That on 18/2/21, the presiding officer of the honorable tribunal passed an order whereby the matter proceeded ex parte against the present applicants. The order dated 18/2/21 would reveal that the matter was taken up through video conferencing mode. The order also revealed that 9/1/21, the counsel of the opposite party had issued notices upon the applicants through 2 newspapers, namely Times of India and Dainik Asam. Then thereafter, my lord, page 100, my lord may kindly
No,
see.
why the notice may not be treated as served through paper publication?
No, at that time, we have to see the situation when the COVID was
Where
going on,
is
the
that?
paper publication was.
Where is that ground you have made? You have not mentioned that you were.
No, in para 9, may I see page 100. The applicant had no prior knowledge about the pendency of the original application number 88 of 2020, page 100, my lord, prior to 28/8/24. And the said knowledge about the judgment and order dated so and so came to the knowledge of the applicants only on
No, but
28.
if the notice is published in newspaper, a deemed service may be resumed.
As regards the paper publication, paragraph 11, my lord. The applicant states that as regards the paper publication that was made in Times of India and Dainik
Para?
Asam, para 11, page 101. It is submitted by the applicant that Times of India is not a local newspaper, which is a wide publication in the state of Assam. Similarly, newspaper Doinik Assam also does not have a wide circulation within the state vis-a-vis the other leading newspapers. It is pertinent to state here that at the time, which is important, my lord, when the newspaper publications were made, there were widespread lockdown throughout the state of Assam, and newspaper circulation was also limited therein. And the period when the COVID-19 pandemic was in full peak. Thus, in that view of the matter, the applicants were prevented from contesting before this honorable tribunal. So this is the relevant paragraph, my lord. COVID-19 was at its peak, my lord. So paper publication.
And you did not have access to the newspapers.
Yes, my lord.
Where is that statement? Because of the pandemic.
Both the newspaper are widely circulated, your lords.
No,
In the
but
local-
their plea is that it was locked down
Yes.
and the newspaper circulation of newspaper was also restricted.
No, your lordship, so that have to be proved.
In my revision petition that I have taken that plea, my lord. Even this is fair submission enough that to show that during the COVID-19 period, there was newspaper circulation was at its bare minimum. And they have relied upon a judgment in the DRT of a Allahabad
No,
High
no,
Court judgment.
no, I'm not on that. I'm on basics. It was published through newspapers.
Yes,
You have to take a plea that because of this or that reason, you did not have access to newspaper. Only then your plea can be appreciated. That statement is not there, that you were, for some reasons, you did not have access to newspaper.
Impliedly it can be construed from this paragraph 11, which says that white paper, it was not, there was limited, the newspaper publication was limited, because this is not a ground, this is a statement which I have made. This is a statement which I have made. This is not a ground, my lord.
Ground for?
Paragraph 11 is a ground, this is a statement which I have made. The applicant has made a statement.
No, this, on what, for what, what grounds the tribunal ought to have
The tribunal's order, it is very cryptic, my lord,
condone the delay.
because what,
For condoning the delay, tribunal must reach a conclusion that
yes, the finding of the tribunal that each and every day delay has to be,
that may not,
that is a wrong finding.
that
because
may be wrong finding.
That is a wrong finding, my lord. Because the tribunal has to consider the entire aspect, the entire period has to be seen. And there are judgments of the apex court which says if a third party right has not been created, generally the delay condonation has to be allowed.
Yes.
Yes, your lord.
His main plea is that notice was not served on him. That is reflected in the order.
Yes, your lord.
It is presumed to be served because of through paper publication. And the paper circulation of newspapers were restricted during COVID periods. And that fact was not taken into consideration while rejecting his prayer.
Your lordship, at that time, if it was not in circulation, then the publication could not have been happened.
No, he's not saying so. He's saying it was newspapers were there in publication, but circulation was restricted due to COVID, and that aspect was not taken into consideration. And yes,
Paragraph 8 of this judgment, my lord, 2014 1 SCC 592. Paragraph 8. It is
yes, please read.
It is correct that condonation of delay cannot be a matter of course. It is also correct that seeking such condonation, the state cannot claim any preferential or special treatment. However, in a situation where there has been no gross negligence or deliberate inaction or lack of bona fide, this court has always taken a broad and liberal view to advance substantial justice instead of terminating a proceeding on a technical ground like limitation, unless the explanation furnished for the delay is wholly unacceptable, or if no explanation whatsoever is offered, or if the delay is inordinate, and third-party rights has become embedded during the interregnum, the courts should lean in favor of condonation. No third-party right has been created. Now the matter is pending before the recovery officer. I only want to contest the case. There is no other further prayer. The applicants want to contest the original application if the honorable tribunal grants the applicants a liberty to file a written statement.
Yes,
Your Lordship, that first of all, that the original proceeding has already been closed. And it is in the advanced stage at the execution proceedings. And at the advanced proceeding, in the execution proceeding, the applicant has come up with a plea that they have not received any kind of notice. But they know that they have taken a loan. It is not that they have not taken a loan. And they have not even tried to pay the loan. And at this stage, they have come up and both the orders are challengeable, Your Lordship. The order of the Debts Recovery Tribunal presiding officer, the original order, which they seeks for vacating of an ex parte order, that is also appealable under DRAT, under the provisions of the Recovery of Debts
that
Act.
is appealable.
Yes,
You have not preferred any appeal.
no, Your Lordship. And besides that,
Appealable under what provision?
Section 20 of the Recovery of Debts and Bankruptcy Act, 1992.
You have filed any objection
Yes, sir.
in this case?
Yes, Your Lordship.
You have filed objection.
Yes, sir.
Objection he has filed before the tribunal.
Tribunal, to the petition, I have filed an objection. And to this present petition, I have not filed an objection because just day before yesterday, I have received the copy, Your Lordship.
You file a written objection.
Yes, sir.
Let him file written objection.
Let notice be issued, and in the meantime, they may not take any.
No,
coercive
we
steps.
will dispose it of next week. Let him file. Let
Yes.
him bring on record his plea.
Yes.
Heard Mr. S. Count, learned counsel for the petitioner. Also heard Mr. M. Sharma, learned counsel appearing for the sole respondent. Learned counsel for respondent seeks some time to file written objection against the application filed by the petitioner in this case under Article 227. The prayer is allowed. When will you file?
Your Lordship, just after this Diwali vacation, Your Lordship, I think it is ended up on 22nd. Matter may be come up on Friday, Your Lordship.
Can it be on 27, my lord? 24, there is some difference.
Let this matter be listed on 27th of
Monday.
October in admission column.
Hello.
He recorded Rakhi. Yes,
Right, please, Your Lordship. Lordship, this is a statutory appeal against dismissal of a probate proceeding, testamentary case, Your Lordship. The probate suit was dismissed because the property mentioned in the will was a little more than the actual property that was with the testatrix. On that ground solely, without considering anything else. the probate
heard Mr. B. J. Mukherjee, learned counsel for the appellant. This appeal under Section 299 of the Indian Succession Act has been preferred by the appellant, Srimati Mili Datta, impugning the judgment and order dated 9/7/2025. 9/7. It is within limitation.
was filed within limitation.
9/7/2025. Passed by learned District Judge Kokrajhar in testamentary suit number 1/2025, whereby the said suit was dismissed. issue notice to the respondents and call for the records of the testamentary suit number 1/2025 from the trial court. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
That would be admitted.
The appeal is admitted.
May it please your lordship. Your lordship, in this appeal, we are taking recourse of three substantial questions of law. It is in page number 10 of the MFA, your lordship. The first one is whether the learned commissioner was well within the ambit of law to construe the injured, which was the conductor of the bus, your lordship, as a skilled labor.
Where are the substantial questions?
Page number 10, your lordship.
Yes. First one is whether the land. First one is not a substantial. Second one,
Second one, your lordship, whether the commissioner was right to direct the insurance company to pay 12% interest per annum from the date of the accident.
how it is substantial question?
Your lordship, this is just an additional.
This is not a substantial question. Third one is,
Third one, your lordship, whether the learned commissioner was right to accept the medical expenditure of the claimant to the extent of rupees.
this is also not a substantial question.
Yes, your lordship. For that, your lordship, the perusal of the record will be necessary for the third one.
Appeal under Workmen Compensation Act is admissible only when substantial questions of law are there. But if it is not there, it need not to be admitted. It may be dismissed at admission stage. You have to satisfy that.
Your lordship, the third one, for that,
Now, which one is the substantial question? Question has to be substantial, not mere question of law. It has to be substantial question of law.
your lordship, the main substantial question of law is the first one, whether the claimant who was the conductor of the bus, he can be construed as a skilled labor. For that, the claimant have to prove that he is a skilled labor. And whether the learned commissioner can construe the means the claimant who was the conductor of the bus as a skilled labor.
Okay, we'll formulate that one.
Okay.
Heard Mr. S. Datta, learned counsel for the petition appellant. This appeal under section 30 of the Workmen's Compensation Act 1923 has been directed against the order dated 30/1/8/2023 passed by learned commissioner Workmen's Employees Compensation at Tejpur Sonitpur in EC case number 6/2015. How much compensation was awarded?
5 lakh, 36
Whereby and the compensation amount of rupees 5,36,150.75 was awarded to the respondents. After hearing learned counsel for the petitioner and going through the memo of appeal and connected documents, Following substantial question of law is formulated in this case. Within number one, within inverted comma, whether the learned commissioner was well within the ambit of law to construe the injured within bracket conductor of a bus bracket close as a skilled labor inverted comma close. Number two, whether the learned commission, the order passed by learned commissioner on 31/8/2023 in EC case number 6/2015 is perverse in as much as the claimant in his cross-examination has admitted that he had submitted a total medical expenditure bill of 1,53,385 only, whereas the commissioner, learned commissioner in the aforesaid order accepted the medical expenditure of the claimant to the extent of rupees 2,21,150.75 only. Issue notice to the respondents.
Your
And-
lordship, respondent number 1 and 2 is already appearing. Their names are reflected in the cause list.
But notices have not been issued.
But your lordship, there was a delay. In IA, they were
in
appearing. and
delay, they have appeared.
Yes,
In
Your
main case,
Your lordship, even now in the cause list.
but they have not appeared.
Yes, your lordship.
Notice has to go. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Your lordship, there is an IA also. IA number 2898 of 2000.
After service of notice, after appearance of
Okay, your much obliged.
May I please, lordship?
May it please the lordship. Lordship, I am appearing for BTC lordship on behalf of Mr. A.K. Bhuya, my lord. He has been newly appointed as the standing counsel of BTC, and we do not have the copy of the petition lordship. So lordship may kindly take up this matter any other day, lordship.
no, we'll issue notice, we'll direct them to furnish you.
Right.
What is this?
My lord, the petitioner was appointed as Anganwadi worker in a mini Anganwadi center in Dotoma ICDS project. Respondent number 5 filed a case that my certificate was fake. Then the matter was referred to the learned civil court, and civil just passed this order that lordship may kindly see page 76. But the present principal say their certificate is fake, but actually the certificate was issued by another principal, that is Talukdar.
No,
All things are
in
here.
the
with us.
title suit number 19, you
Madam?
were the plaintiff.
Yes, I am a plaintiff.
Plaintiff, your suit was dismissed.
Yes, I am dismissed.
Therefore, you have
Yeah.
appealed. Okay. Heard,
And thing is
Mr.
this, my lord, the principal has,
No,
yeah.
we are issuing notice. Heard.
record may kindly be called for because
Yes, yes.
voluminous witnesses are there.
Heard Mr. M.U. Mahmood, learned counsel for the appellant. Also heard Mr.
J. Das on behalf of Mr. A.K. Bhuya.
J. Das, appearing on behalf of Mr. A.K. Bhuya, learned standing counsel BTC. Also heard Ms. D.D. Burman, learned additional senior government advocate appearing for respondent number 1. This appeal under section 96 of the Code of Civil Procedure, 1908 has been preferred by the appellant Shahinur Bibi, impugning the judgment and decree dated 30/8/2025, passed in title suit number 19/2022 by the Court of Learned Civil Judge Senior Division Kokrajhar, BTR Assam. Issue notice to the respondents. Since respondent number 1 and 2 are represented by the respective counsel, no formal notice need to be issued to the said respondent. However, the appellant is directed to furnish requisite number of copies of memo of appeal along with the annexures to the learned counsel for the said respondents. Who is appearing for Joint Director comes Social Welfare BTR?
Which is say,
You are appearing.
Only 5 and 6 will go by registered.
4 also you are appearing.
my lord.
Okay, no, since no, since 1, 2, 3, 1, 2, 3 and 4 are represented. 1, 2, 3 and 4. Stop. As regards respondent number 5 and 6, the appellant shall take steps for issuance of notice upon the said respondent by registered post with AD, as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the records of title suit number 19/2020 be called for from the trial court. Stop. This appeal is admitted. Stop. List accordingly after 4 weeks.
In this case, 15 lordship, I am extremely sorry, lordship, that without lordship, depositing the statutory deposit of 25,000 lordship. Yes, 25,000 lordship. I have filed this appeal lordship, but today morning I have deposited the sum before the registry. That's it.
You give a copy of this photocopy. Photocopy এটা করি, original return করে দিব, photocopy record.
Originally, the file lordship.
Yes. Heard Miss D.D. Burman, learned counsel for the appellant insurance company. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant, that is National Insurance Company Limited, impugning the judgment and award dated 10/7/2025 passed by the Motor Accident Claims Tribunal Dhubri in MAC case number 18/2022, whereby an award of rupees 23,04,000 was given in favor of the respondent claimants. Stop. Learned counsel for the appellant submitted that though this appeal was filed by the appellant without depositing the statutory deposit of 25,000, however, today the appellant has deposited the said amount before the Registrar General, and to substantiate her submission, she has produced the letter dated 17 October 2025 and the photocopy of check number 186764 by which the said deposit was made. Let the said letter be kept in the record as a part of it. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the records of MSC case number 18/2022 within bracket D be called for from the concerned tribunal. List accordingly after 4 weeks.
I have filed the I for stay of the judgment.
Will you deposit 50% now? Or should we issue notice? Same, heard Miss D.D. Burman. This interlocutory application under Order 41 Rule 5 has been filed. No, under Order 41 Rule 5 Nilikhebo. This interlocutory application has been filed by the applicant/appellant impugning the and praying for stay of the execution of the impugned judgment and award. Stay of the execution of the judgment and award dated 10/7/2025 passed by London member, Motor Accident Claims Tribunal Dhubri in MSC case number 18/2022, whereby an amount of rupees 23,04,000 or 23,04,000 was directed to be paid as compensation to the respondent number 1, 2, 3, who were the claimant of the said case. Stop. Since learned counsel or the applicant is ready to deposit the 50% of the awarded amount as a condition precedent for staying the execution of the impugned judgment and award, notices to respondent are waived in this case. And stop. The notices to respondent are waived in this case. Stop. Accordingly, the impugned judgment, accordingly, the execution of the impugned judgment and award dated 10/7/2025 passed in MSC case number 18/2022 by the Motor Accident Claims Tribunal Dhubri shall remain stayed during the pendency of the connected MSC appeal number 468/2025, subject to the condition that the applicant/appellant shall deposit 50% of the awarded amount before the registry of this court within 4 weeks from the date of this order. This interlocutory application is accordingly disposed of.
MSC case number, Lordship, 18/2022 bracket D, Lordship, capital D.
18/2022 within bracket capital D.
Item 16.
May it please your lordship. Lordship, this is a statutory appeal. I prefer the appeal on the ground of quantum, lordship.
Quantum.
Lordship, only quantum, lordship. We are ready to deposit 50% of the award, lordship.
There is an I also.
Lordship.
Heard Mr. S. R. Sharma. Heard Mr. R. Sharma. Learned counsel for the appellant. This appeal under section 173 of the Motor Vehicle Act 1988 has been filed by the appellant insurance company, that is the Oriental Insurance Company Limited, impugning the judgment and award dated 7/4/2025 passed by the London Member Motor Accident Claims Tribunal, Hailakandi, MSC, in MSC case number 115/2021. Stop. The appellant is mainly aggrieved with the quantum of compensation awarded by the Motor Accident Tribunal, Motor Accident Claims Tribunal in the aforesaid case. This appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the records of MSC case number 115/2021 be called for from the concerned tribunal. List this matter accordingly after 4 weeks. This interlocutory application has been filed by the applicant insurance company, praying for stay of the execution of the judgment and award dated 7/4/2025, passed in MSC case number 115/2021 by London Member, Motor Accident Claims Tribunal, Hailakandi, whereby an award of rupees. How much? 27 lakh.
28,000.
28,000 was awarded in favor of the claimant opposite parties. Stop. Since the applicant has impugned the aforesaid judgment in the connected MSC case number, MSC appeal number 470/2025, and mainly against the, mainly on the point of quantum of the awarded amount. And since the applicant insurance company is ready to deposit 50% of the awarded amount as a condition precedent for staying the execution of the aforesaid award, notice to respondents is waived in this interlocutory application. Stop. Accordingly, the execution of the judgment and award dated 7/4/2025 passed by Learned Member Motor Accident Claims Tribunal, Hailakandi, in MSC case number 115/2021, which has been impugned in the connected MSC appeal number 470/2025, is hereby stayed, subject to the condition that the applicant insurance company shall deposit 50% of the awarded amount before the registry of this court within a period of 4 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Deeply obliged.
17.
May I please?
Yes.
Your Lordship,
This claim has, this appeal has been preferred by the claimant for
Dismissed.
enhancement. No, enhancement.
Enhancement.
Your lordship, I sustained disability, but, and also exhibited the disability certificate issued by the statutory body. And also examined the, one of the member of the board. In spite of that, the learned tribunal have not considered that. This is the basic ground.
Heard Mr. D. Mundul, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant / claimant Samsul Nehar Begum, impugning the judgment and award 22/7/2025 passed by learned member, Motor Accident Claims Tribunal, Moregaon, in MSC case number 56/2020. The appellant has been aggrieved by the quantum of compensation awarded by the impugned judgment and is seeking enhancement of the awarded amount in this appeal. Stop. This appeal is admitted. Let the records of MSC case number 56/2020 be called for from the concerned tribunal. Let also the notices be issued to the respondents. Stop. The appellant shall take steps for issuance of notice upon the respondent by a registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Highly obliged.
Please, your lordship. This is an appeal on quantum, it's an injury case. So I will deposit 50%, lordship.
Heard Mr. R. Goswami, learned counsel for the appellant insurance company. This appeal under section 173 of the Motor Vehicles Act 1973 has been filed by the appellant insurance company, namely Magma HDI General Insurance Company, impugning the judgment and award dated 22/4/2025 passed by the Motor Accident Claims Tribunal, Kachar, in MSC case number 254/2018, whereby an amount of rupees 14,72,112 was awarded as compensation to the opposite party claimants. Stop. The appellant is mainly aggrieved with the quantum of the compensation awarded to the claimant. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let also the records of MSC case number 254/2018 be called for from the concerned tribunal. Stop. This appeal is admitted. List this matter after 4 weeks.
Dear lordship. I'll deposit 50%. lordship.
You'll deposit?
50% they can withdraw also.
Now let them appear first. Heard Mr. R. Goswami, learned counsel for the applicant. This interlocutory application has been filed by the appellant applicant/appellant insurance company under Order 41 Rule 5 of the Code of Civil Procedure, praying for stay of the execution of the impugned judgment and award dated 22/4/2025, passed in MSC case number 254/2018 by the Motor Accident Claims Tribunal, Kachar. The applicant has impugn the aforesaid judgment by preferring the connected MAC appeal number 472/2025. The applicant is aggrieved mainly with the quantum of the compensation amount awarded to the claimant respondents. Stop. Since the learned counsel for the applicant has submitted that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition precedent for stay of the execution of the impugned judgment and award, notice to the opposite party in this interlocutory application is waived. Stop. Accordingly, the execution of the impugned judgment and award passed in MAC case number 254/2018 by the Motor Accident Claim Tribunal Kachar is hereby stayed, subject to the condition that the applicant insurance company shall deposit 50% of the awarded amount before the registry of this court within a period of 4 weeks from the date of this order. This interlocutory application is accordingly disposed of.
19. This is an award for third party property damages. Property is the vehicle of the claimant also was damaged.
Damage to the vehicle.
Damage to the vehicle. Claim loss is subject to 50% because what is happening, it is a partial loss. And the learned tribunal has given more than the value of the vehicle.
Heard Mr. R. Goswami, learned counsel for the petitioner, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act has been preferred by the appellant insurance company, namely National Insurance Company Limited, impugning the judgment and award dated 9/6/2025, passed by learned Motor Accident Claims Tribunal Sonitpur, Tejpur in MAC case number 2/2024 within bracket capital PD. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the records of MAC case number 2/2024 within bracket PD be called for from the concerned tribunal. This appeal is admitted. List this case after 4 weeks. I heard Mr. R. Goswami. This interlocutory application has been filed under Order 41 Rule 5 of the Code of Civil Procedure, praying for stay of execution of the impugned judgment and award dated 9/6/2025, passed by learned member, MACT, Sonitpur in MAC case number 2/2024 within bracket PD. The aforesaid judgment and award has been impugned by the present applicant by preferring the connected MAC appeal number 473/2025. By the impugned judgment and award, the tribunal, the Motor Accident Claims Tribunal Sonitpur has awarded a compensation amount of rupees 3,51,310 to the claimant opposite parties. Stop. Learned counsel for the applicant has submitted that the applicant slash appellant insurance company is ready to deposit 50% of the awarded amount as a condition precedent for staying the execution of the impugned judgment and award. Stop. In view of submission of the learned counsel for the applicant, the notice to the opposite party respondent is waived. Notices are waived. Accordingly, the execution of the impugned judgment and award dated 9/6/2025 passed by the Motor Accident Claims Tribunal Sonitpur in MAC case number 2/2024 within bracket PD is hereby stayed, subject to the condition that the applicant insurance company shall deposit the 50% of the awarded amount before the registry of this court within a period of 4 weeks from the date of this order. This interlocutory application is accordingly disposed.
Item 22.
Thank you, Lordship. Lordship, this matter will be kindly taken at 2 p.m. my lord.
This matter,
At 2 p.m. my lord.
why?
My senior Mr. M.K. Sharma is at session for my lord for his close examination of one.
Okay, at 2 p.m.
Item 23 forward.
May I please, Your Lordship? Your Lordship, as per order dated 30/5/2025, we were to take instructions whether the engaged counsel appearing for the respondent shall appear for the remaining respondents or not. So that they have accepted. that
Lordship,
they-
we can appear for all the respondents, Your Lordship.
Okay.
Service is complete.
Heard Miss R. Chaudhary. What is your name? Heard Miss P. Hajorika. B. Bombay. Heard Miss B. Hajorika, learned counsel for the petitioners. Also heard Mr. B. J. Mukherjee, learned counsel for all the respondents. Stop. Since all the parties have appeared in this case is ready for admission hearing.
Matter was admitted, Your Lordship.
It has already been admitted,
The old pending matter date may be fixed for final hearing.
final hearing. Since this matter has already been admitted and parties have appeared, it is ready for hearing. Let this case be listed for final hearing on
After opening, Your Lordship. In the month of November, any date, Your Lordship.
in the 3rd week of November on a date to be fixed by registry. The interim order shall continue till next date.
Item 24.
May it pleases your lordship. Lordship, as per office note dated 26/9/2025, answer notice has been received in respect of respondent number 4. Lordship, we will take case steps after ascertaining the correct address of the respondent number 4, Lordship.
Justice Service. My lord, in this matter, I am representing respondent 1, 2, and 3, my lord. And as office notes, my lord, the service records of the original trial court title suit 54/5 received. So far as the LCR of the title appeal yet to be received, my lord. And the suit of 2005, my lord, I am the owner, they are a tenant, my lord. This dispute since 2005, my lord. So let them take even justice service in if necessary. In 2005, this issue involved landlord tenant.
Can you take the service?
Like, please try.
We will try, but.
But they
Lordship,
don't
the
know the address.
Address, that's the issue,
Then
Lordship.
these things will continue, will keep pending.
They will linger the case. They will remain in your tenanted premises.
Yes, my lord, this is now 2025, 20 years, my lord.
This is a RSA of 17 years,
Yes, my lord.
2017.
So alternative.
Why you don't know? Who is respondent number 4?
One of the legal heir of the original defendant, Lordship, Jivan Chandra Ganguly.
You must be knowing the address
My
of,
lord. Lordship, I will ask my client, my lord,
you provide the,
I'll try my best.
because he is your legal heir only.
Executive. Okay, lordship, I'll.
Heard. Miss, what is your name?
B. Devi Lordship on behalf of Mr. S.P. Chaudhary.
Me, B. Devi, appearing on behalf of Mr. S.P. Chaudhary, learned counsel for the appellant. Also heard Mr. B. Deka,
PK Deccan.
sorry, P.K. Deka, appearing for respondent number
1, 2, and 3.
1, 2, and 3. It appears from office note dated 26/9/2024 that notices issued to respondent number 4 by registered post with AD has returned back without service with an endorsement within inverted comma. No such person in the address, inverted comma close. Since respondent number 4 is the legal heir of the original defendant, learned counsel for the respondents is requested to inquire about the correct address of the respondent number 4
Lord.
and inform the same to the learned counsel for the appellant within a period of 15 days. 15
Before that, I could not, I definitely answer.
within a period of 7 days.
Yes, my lord.
7 days. Thereafter, if stop within a period of 7 days, stop. Thereafter, if new address is available, the appellant shall take fresh steps for issuance of notice upon the respondent number 4 on such address by registered post with AD as well as by usual mode within next 15 days, next 7 days, returnable after 6 weeks.
And you know, LCR of the
Thank you.
appellate court.
Let also a reminder be issued for requisitioning the records of the first appellate court.
Yes, my lord.
Registry to take steps for issuing reminder
Deeply obliged.
list accordingly.
Deeply.
Item 25.
May I please? In this matter, also, the actual appellant has expired, Lordship, but our APJ request none has come forward for substitution. So, Lordship may pass.
In fact, it has been awaited. She died way back in 2021.
22.
And 21 or 20, whatever it is, a statutory period of 5 months long over.
When, what is the date of death?
23/1/2022.
23?
1/2022.
Heard Mr.
A. Borua.
A. Burwa, learned counsel for the appellant. Also heard Mr. S. Datta, learned senior counsel assisted by Ms. S. Mushahari, learned counsel for respondent number, all respondents.
My lord, no. My lord, we are appearing on behalf of 1 to 4. 1 to 4.
Appearing on behalf of 1 to 4. It is, any death certificate is there?
Yes.
Give a copy of that.
Yes.
Learned counsel for the appellant submits that the sole appellant, only one appellant is there.
Yes, yes.
Sole appellant, Miss Rumi Borkakoti, had expired on 21/1/2022 and To substantiate his submission, he has submitted a copy of death certificate of the sole appellant. He further submits that no one has come forward as legal heirs of the deceased appellant so as to make a prayer for substituting them in this appeal. Stop. Stop. Let the death certificate of the appellant Rumi Borkokoti be kept in the records of this regular second appeal. As no legal heirs have been substituted within the stipulated period of 90 days as provided by the statute, this regular second appeal has abated. Nothing more is required.
Yes, your lordship may refer a judgment also, my lord. That will,
Why judgment is required?
no, it's not required at all, only
What-
thing, my
what-
lord,
what
when
is-
it is awaited is by operation of law.
Operation of law.
So therefore, there is no requirement of any adjudication. That has been said.
Yes.
the Honorable
There
Appeal
is a provision in the Guwahati High Court rules that when, I forgot the exact provision, when a judgment is awaited, when a case is abated on death of the petitioner or appellant,
Right.
and there is no prayer for substitution within
within the statutory period,
statutory period of time,
it automatically abates.
then by operation of law,
Very good.
but an endorsement to that effect has to be made by the registrar,
Yes, yes,
but that is not being followed.
yes. Only the court can take cognizance to end the matter. That has
Yes.
been said by the Supreme Court
Yes.
in paragraph 5.
Kili, last. Accordingly abated, stop. This court accordingly take note of the said abatement, take note of the abatement of this regular second appeal and record the closure of this regular second appeal as having abated, as having been abated. Stop.
Obliged.
Item 26.
Chamber.
May I please allow you? First, as per office note dated 14/8/2025, my lord, answer notice has been received back with postal note insufficient address. My lord, we have already taken 2 times steps, my lord.
Now what is your submission?
But they have already agreed for mutual divorce, that they have filed one affidavit.
No,
my lord, we
regarding service of notice.
My lord, insufficient, my lord, we have taken steps for 2 times, my lord.
Your husband or wife?
I'm-
But notice has to be served.
My lord, they have agreed for mutual divorce, my lord, this is an agreement, my lord.
Oh, that is a different aspect.
Since it is pending
Nah.
since 2019, my lord.
When have you taken steps? Insufficient address. You have not mentioned the proper address.
My lord, I have that address also. my lord.
You must be knowing the address. You have to take fresh steps. When have you taken steps?
My lord, on 3/6/2025, my lord.
It is to be done.
And since they have mutually agreed,
No, that is a different aspect. Now we are on the question of due service of notice. Once you cross this hurdle, only then we can go into other facts. So how to overcome this hurdle of either by newspaper publication or by taking fresh steps and submitting the track consignment report? Heard, Miss, what is your name?
PM Ahmed, on behalf of Mr. A.
B.A.
PM.
PM, na, PM Ahmed, learned counsel for the petitioner. On perusal of office note dated 14/8/2025, it appears that the notices sent to the sole respondent by registered post with AD has returned back without service with an endorsement, with a postal endorsement within inverted comma, insufficient address, RTS. What is the address?
Upper Police Colony, PO Naharlagun, District, Arunachal Pradesh.
No, you in registered post matters, you have to mention the PIN number. Unless you mention the PIN code, it will always be returned without.
And the PIN number is there, 791110.
That is. You take service of notice on both the addresses,
Permanent as well as residence.
permanent as well as present address, and write the full name of the father of the petitioner, father of the Kilikilas. It appears on perusal of the transfer petition that two addresses are mentioned in the petition of the two addresses of the opposite party has been mentioned in the petition. The petitioner is therefore directed to take fresh steps on both the given addresses of the opposite party by registered post with AD within 7 days from the date of this order, returnable on 28th of November. It is clarified that while mentioning the name and address of the petitioner, respondent, opposite party in the notices to be issued to the said opposite party, the full name of the father of the opposite party shall be reflected therein. List accordingly on 28 November 2025.
27.
None has appeared.
27.
Trial court recorder, I say. None has appeared for the appellant on call. Let this matter be listed again after 2 weeks on a date to be fixed by registry.
28.
My lord, it is seen that the opposite party number 1 and 2 are actually not required because by the order of passed by the Lanet Trial Court, it is seen that the favor of the insured. So it is actually a case of against the insurance party. So the notice to the opposite party number 1 to divert owner is not required, my lord. So I have challenged the order of the Lanet Tribunal At page 18, my lord, it is order passed by the MSCP. That means the time is
You are the claimant.
claimant. Only 20,000 is ordered by the trial court. Only 20,000. Did not make any calculation as per the law required under the law.
Whether the trial, the records of
And sir, I think has come. Maybe dispose of ballot not is an old case, and this claimant is an old woman. If you lordship kindly let me allow me to read the order, your
No,
lordship will
no.
see.
You have to be slow. First, we have to take decision regarding issuance of notice on respondent number
1 and 2.
1 and 2. Some decision has to be made. Thereafter,
Yes.
you have any submission?
My lord,
You are the insurance company.
because my lord, and otherwise, my lord, since we have already paid, there is a no dispute regarding the validity of RCA.
This case is for enhancement.
For NSP. That is why maybe struck off 1 and 2.
You make a written prayer.
Hello?
Written prayer to dispense with the notice.
Written argument.
No. Yeah.
Huh?
To strike down the 1 and 2.
I have made this verbal submission.
Heard,
They are not
Mr.
necessary.
Heard Mr. R.C. Saikia, learned counsel for the appellant. Also heard Mr. R.C. Paul,
That's one number 3.
learned counsel for respondent number 3. On perusal of the. No, but you have not even taken steps. You have to at least take steps.
My lord, just a minute. My lord, while I have gone through the judgment of this case,
No. That,
actually, they are not necessary at all.
no, that is a different aspect.
My lord,
When court has directed you to take steps.
that day it was directed, but when I have gone through the judgment, because I have got the judgment of the our High Court and the Appeals
There
Court.
is a delay.
Just a
Delay
minute,
was
just a minute. When the order reflects that they have insurance company, actually case was against insurance company and the vehicles were insured. So unnecessary, the case should not be kept pending.
No, that is one aspect. Other aspect is when court has directed you to take steps. No, you cannot choose not to obey court's order.
But what the steps actually was taken? I have brought it.
When?
Steps were taken not long back. 8/10/21. My humble submission that this old lady who is physically ill, lordship, and kindly see the order passed by the trial court that without any calculation, without anything, lump sum amount of 20,000 given is very rare in the history of the claim case. Only 20,000. The severe injuries took place. It was admitted the trial court.
Stop.
There was the evidence also.
What was the last line? On perusal of the office note dated 14/10/2025, it appears that the records of the concerned MAC case has been received by the registry. It also appears that the the appellant was directed to take steps for service of notice on the respondent number 1 and 2 by registered post with AD, who are the driver and owner of the when you took steps.
The steps were taken earlier than that on 8/10/21. This is the receipt. We have taken steps, my lord. Twice we took the steps on 15/2/19. Then again, that's postal Talabana.
You take fresh steps.
My lord, while my submit, I made the submission by lordship, that they are not necessary party at all. That may be recorded by lordship,
Then why you made them party?
because while the case was filed at that time, their names were there in the original claim case, and when the judgment was passed, first cause of action is arisen. First cause of action is
Because, my
arisen,
lord,
lordship.
the
Because,
the
because
step
they are,
was taken in the case of delay of condemnation petition. Delay was condoned. While then
In delay condemnation petition, they appeared.
I appeared, they did not appear. 1 and 2 did not appear. Subsequently, delay was condoned.
Lastly,
but delay was condoned.
And thereafter,
Delay condoned proceed.
stop. However, learned counsel for the appellant has submitted that the respondent number 1 and 2 also did not appear in the interlocutory application where the notices were issued to them. Interlocutory application filed by the present appellant for condonation of delay, where notices were issued to the said respondent. He submits that since the grievance in this case is regarding quantum of the compensation awarded to the appellant, the presence of respondent number 1 and 2 may not be necessary for disposal of this appeal, and therefore he verbally prays for striking out the name of respondent number 1 and 2 from the memo of appeal. The prayer is allowed. The registry shall strike out the name of respondent number 1 and 2 from the memo of appeal. Stop. Let this case be listed for hearing.
Revision hearing. And that on that day, lordship will can dispute. the
Not
case.
admission hearing.
Admission hearing.
It is already admitted.
Why?
How it will again go back to admit
Okay.
hearing, my lord.
for hearing
In the month of November.
in the first week of November, in the second week of November, on a date to be fixed by registry.
Obliged.
Much.
Obliged.
Item 29.
May plead your lordship. As per last office note 25-9 lordship, service report is awaited in respect to respond number 2B.
What is to be done?
Can wait for some time, lordship.
Heard Ms. P. Bhattacharya, learned counsel for the appellant. Also heard Mr.
A Deka, my lord.
A.
Appearing on
Deka.
behalf of BD Deka, my lord.
Appearing on behalf of BD Deka, learned counsel for respondent number 1. None has appeared for respondent number 3. It appears from office note dated
5-9.
25/9/2025 that the service report in respect of respondent number 2 within bracket B is still awaited. Stop. Await further for 2 weeks. Let this matter be listed after, again after 2 weeks.
May I please your lordship? As per the office note dated 24/9/2025, service in respect to respondent number 3 and 4 has complete and LCR also come. The matter may come up for hearing.
Who is appearing for? You are appearing for?
I'm appearing for 1, 6 and 7. Since
Who is
the
it?
service is complete, your lordship can fix the date for hearing.
Heard Mr.
R.K. Mohanta.
R.K. Mohanta, learned counsel for the appellant. Also heard Mr. S. Datta, learned senior counsel assisted by Ms. S. Mushahari, learned counsel for respondent number 1, 6 and 7. On perusal of the office note dated 18/9/2025, it appears that notices issued to respondent number 3 has been duly served. Stop. The service of notice on all respondent is complete. And the records of the trial court as well as first appellate court have also been received. This case is therefore ready for hearing. Let this matter be listed for hearing after 3 weeks on a date to be fixed by registry.
Not over.
Yes, Mr. Lordship. Lordship, I am appearing on behalf of my senior, Mr. N. Dhar, and for the applicant.
Yes. Whether service is complete on all respondents.
Lordship, respondent number 4 has expired.
Mr. Chaudhary, you are appearing for?
Respondent number 3, Lordship. So 1 and 2 probably they have to take fresh steps.
For other respondents,
For other respondent service is complete. 1, 2 and 6, there is an office note that to that.
1, 2 and
1,
16.
2 and 16.
Heard,
and
Miss,
four
what is your name?
It's R. A. Chaudhary.
R.
R. A. Chaudhary.
R. A. Chaudhary, learned counsel for the appellant. Also heard Mr. S. P. Chaudhary, learned counsel for respondent number 3. On perusal of the office note dated 26/9/2025, it appears that the notices issued to respondent number 1 and 2 have not yet been returned back. It also appears that the appellant has not taken any steps for issuance of notice in respect of respondent number 16. Stop. The appellant is further, if you don't take steps as per the direction of the court, then your appeal will be dismissed.
Your Lordship will take fresh step.
The appellant is directed to take fresh steps for issuance of notice upon respondent number 1, 2, and 16 by registered post with AD within 7 days from the date of this order, returnable after 4 weeks, list accordingly.
Item 33.
In this case, my lord, the respondents have filed one objection on the ground of maintainability. We want to file reply to that. Only a week's time may be allowed.
Services complete LCI receipt may be fixed for admission, and we have filed objection on the point of maintainability. On that day. But this
On
is
that,
not,
we want to file reply.
this is not to track with the case record. Objection is not.
We'll fix it for admission hearing. Before that, you may file objection.
But it may be directed to take my objection in the record.
It is not there on record.
This is not a court. Last week I have filed.
Heard Mr. What is your name? Heard Mr. S. Upadhyay, learned counsel for the petitioner. Also heard Mr. K. Sharma, appearing for learned counsel for respondent number
1 and 2 both.
1 and 2. Learned counsel for the respondent number 1 and 2 has submitted that the said respondent have filed a written objection against the petition filed by against the instant CRP, against the instant civil revision petition filed by the petitioner. raising the question of maintainability. However, said written objection is not found on record. The registry is directed to put up the said objection along with the record before this court on the next date fixed. The learned counsel for the petitioner submits that he may be allowed to file a reply to the written objection filed by the respondents. The prayer is allowed. He may do so. He may file his written reply to the objection filed by the respondent before the next date fixed, with a copy of the same furnished to the learned counsel for the respondents. Let this case be listed in admission column in the third week of November on a date to be fixed by registry.
Deeply relaxed.
44.
May I please your lordship? Lordship, as per office note dated 1/8/2025, lordship, unserved notice has been received back from respondent number 4, 6, and 7 with the endorsement respondent number 4, addressee not found, 6 and 7 addressee left. And neither edit card nor unserved notice has been received back from respondent number 5 and 8. Lordship, since respondent number 1, 2, and 3, they have entered appearance, and for respondent number 4 and 5, they are the sisters of respondent number 1, 2, and 3. So the council appearing for respondent number 1, 2, and 3, they can
No, you cannot compel them.
Lordship, they can provide the correct address of respondent number 4 and 5, lordship.
Okay. Who is appearing?
Lordship, their name has been reflected in the cause list, lordship.
Heard Miss, what is your name?
MS Das.
Heard Miss S. Das, learned counsel for the appellant. The office note dated 1/8/2025 shows that the notices issued to respondent number 4, 6, and 7 have returned back without service with an endorsement in respect of respondent number 6 and 7, comma, within inverted comma, addressee left, return to sender, and with an endorsement in respect of respondent number 4 as addressee not found, return to sender. Learned counsel for the petitioner, learned counsel for the appellant has submitted that since respondent number 1, 2, and 3 have appeared in this appeal by filing wakalatnama, the petitioner may be, the appellant may be allowed to take proper address of the respondent number 4, 6, and 7.
No, lordship, only for 4 and 5, lordship. 6 and 7, kind of 2 weeks time will be granted to obtain the correct postal
Proper
address.
address of respondent number 4 and
5.
5 from the learned counsel appearing for respondent number 1, 2, and 3. The prayer is allowed. The
Lordship, in respect to respondent number 6 and 7, 2 weeks time will be granted, lordship.
prayer is allowed. The learned counsel for the appellant may obtain the correct addresses of respondent number 4 and
Lordship, 6 and 7.
6 and 7 from the learned counsel for respondent number 1, 2, and 3.
Correct address of respondent number 4 and 5, and in respect to respondent number 6 and 7, 2 weeks time will be granted.
Last. Note. No, instead of 6 and 7. Correct addresses of 4 and 5.
Lordship, from respondent number 1, 2, and 3.
1, 2, and 3. 1, 2, and 3. In respect of respondent number 6 and 7,
2 weeks time will be granted to obtain correct address, Lordship, or to take information. as to which
sometime in respect of respondent number 6 and 7, Learned Counsel for the appellant seeks 2 weeks time to get correct address of the said respondent, and thereafter take steps for issuance of notice. The prayer is allowed. Let this matter be listed after 2 weeks.
But LCR has not been received.
The records of the trial court as well as first appellate court have not yet been received. Issue reminder for the same. The registry to issue reminder for requisition of aforesaid records. List accordingly.
Public Lordship.
45. May it please your Lordship. As per office note, my lord, dated 18/6/25, my lord, no AD card in respect of my lord, respondent number 1 and 2 received, my lord. However, my lord, the usual in as per usual process, we took a step, my lord, and Jarikaro has already served a notice to the my lord respondent, my lord, as per order of 28/6/23, office note, Lordship.
Heard. Mr. What is the name?
H. Rahman, my lord.
A.
H. Rahman, Lordship.
H. Rahman, Learned Counsel for the petitioner. On perusal of the office note dated 18/6/2025, it appears that though the notice is issued to respondent number 1 and 2 by a registered post with AD, has returned without service. However, where is that notice issued?
My lord, 28/6, my lord, usual process, my lord, 28/6/23, office to Lordship.
It only speaks about issuance, not about
The
survey.
report of the process server is there, my lord, in the record. I may be permitted to take first step then, Lordship.
Report of the process. There are only two response.
Yes, that's only two, Lordship. Same address, Lordship.
However, the notices issued through usual mode has returned with a report of process server that notices have been duly served on the respondent, and in acknowledgement whereof the respondent number 1 and respondent number 2 respondent number 1 has put her signature in the notice, as well as the son of respondent number 2, namely Madhurya Gogoi, has also put his signature on the notice in acknowledgement of receipt of the notice. The notices issued to respondents, are therefore, therefore is held to be duly served. Let this case be listed for in admission column on
It's a month of December, Lordship.
after 6 weeks. You are having some interim
Yes, sir, interim is there, my lord. Interim order dated 29.
after 4 weeks. After 4 weeks, interim order shall continue till next.
Like that, sir.
46. That execute service upon the respondent number 2, the office dated 2nd of September reflects that usual process has been served.
Okay.
Sir. But the registered with the AD card has not been received. I think usual process is approved, sir. The respondent
You are
number one
appearing
and-
for?
I, for the respondent, one. My lord, the matter was sent to for mediation.
What happened?
Court is not turned up. I appeared before the mediation. But on that day, the client of my longest friend has not appeared.
What is the matter?
Regarding the probate case in that case regarding witness giving evidence of a witness. I'm not aware of the mediation.
No.
By which order the matter was sent to mediation?
Aware of the-
There is no order,
No order.
no order for mediation.
I have seen some other matter.
Not this matter.
Maybe so.
And the respondent number 1 and 2 are the brothers.
Brothers,
Two probate case was filed. One for father has executed the will. Another case for.
who is
mother
who is the
executed
petitioner?
Petitioner is other sister.
And respondent number 1 and 2 are the brothers.
Brothers. only.
You are appearing for only one brother.
One.
Service is complete with the.
Will the report of process service. Heard Mr. A. Dhar, learned counsel for the petitioners. Also heard Mr. R. K. Jain, learned counsel appearing for respondent number
One.
Respondent number 1. On perusal of the office note dated 2/9/2025, it appears that though the notices issued to the respondent number 2 by registered post with AD has returned without service, has not
Been served.
yet been received back. However, the notices issued by usual mode has returned with a report of process server to the effect that the notice is duly served on the respondent number 2. What is his name? Gautam
Gautam Shah.
Gautam
Aha.
Shah. In acknowledgement of the receipt of the notice, the respondent number 2 has also appended his signatures on the backside of the notice. Stop. Having been satisfied on due service of notice of on the respondent number 2, this court is held. This court hereby holds that The notice is issued to respondent number 2 has been duly served. Stop. None has appeared for respondent number 2. Let this matter be listed. Records will be required.
Courts requirement. Records were not called for.
What is the status?
That suit is pending. Suit is pending and it was.
There
stayed.
is a stay order.
There is stay order of 29th of May
No.
2023.
What you have challenged in this CRP?
There's an order dated. Order dated. Twenty-three, 23,
23,
23, whereby.
Page
my-
number?
Page number 58.
58.
What was done by this order?
Their petition filing under
Our
order 16.
application, yes, that has been rejected.
Or under order?
16.
16,
Or
for adducing witness of evidence of a witness who has already expired. Earlier, this is a second round of litigation. Earlier, this court has allowed us to adduce evidence of 2 witnesses. And during the pendency, one of the witnesses expired. In other proceeding, there are 2 proceedings, probate proceeding. In other proceeding, he has deposed. So we wanted to bring on record his evidence in that proceeding in our.
we are not calling for record. If required, we'll see.
Hello.
We'll fix this for admission hearing.
But that will be.
Hello, there was order by the Honorable Court on 26/11/20, page
Oh.
47.
Page 47.
That was the earlier round of litigation.
What is this order?
In this order, they were allowed. Last page 15, my lord, 50.
They were allowed to adduce evidence.
Yes,
Evidence
Then what happened?
that
by filing petition under order 16, rule 1, sub rule 3, CPC.
Okay, then
They
there are,
filed this petition before the landed trial court.
but
that
the
was
trial court rejected it.
No, in the meantime, the said witness expired. He died. Then they again filed the petition to allow them to submit the evidence under sections 33.
That was rejected.
That was rejected because
Okay.
all the time they are changing their stand in the petition, the different petition.
that will reveal from the all the records.
Okay.
Someone for admission.
Let this matter be listed again in the month of
November, madam?
November.
But my submission is after 3 weeks, it will be middle of the November.
After 3 weeks, on a date to be fixed by registry. Interim order is there. Interim order shall continue till next day.
Apply.
47.
Please allow.
Yes.
In this case, my lord, the petition, today I have come to know the petitioner is died about 15 days back, your lordship. Sole petitioner. So I have to file substitute petition.
Okay.
So as to getting the legal.
Heard.
rights.
Mr. A. Rahman, learned counsel for the petitioner. Also at Miss P.
A Burma,
A. Burman,
phone number 1A, 1B, 1C.
learned counsel for respondent number 1A, 1B, and 1C. You are also appearing. Also at Miss D. D. Burman, learned additional senior government advocate appearing for respondent number 2, 3, and 4. Learned counsel for the petitioner has submitted that he came to know that the petitioner has expired about 15 days ago. And in view of that, he's prays for some time to take appropriate steps for substituting legal heirs of the deceased petitioner. The prayer is allowed. let this matter be listed after the taking of appropriate steps by the petitioner as prayed for.
Apologies.
Item 38. May please be moved. Looks if this is a continuation of delay petition lordship. And service is complete. 247, 63 days.
How many, how much
263
delay?
days.
60?
3 days. 263 days.
You are insurance company.
No, my lord, I'm,
I'm for the claimant.
Claimant.
This is when the API was.
You are opposing
yes, I'm respond number 1.
regarding his prayer for condoning the delay. No objection. Heard Mr. A.R. Agarwal. Learned counsel for the applicant. Also heard Mr. R.C. Paul. Learned counsel for the respondent number 1. This
Explained in pair number 3.
This application under Section 5 of the Limitation Act 1963 has been filed by the applicant praying for condonation of delay of 263 days in preferring the connected MSc appeal by which the applicant has impugned the judgment dated 30/9/2022 passed by learned member, motor accident claims tribunal number 2, Kamrup Metro in MSc case number 1758/2017. The applicant has stated the ground for approaching this court belatedly for filing the connected MSc appeal in paragraph number
3, 4 and 7.
3, 4 and 7 of the instant application for condonation of delay. Stop. Considering the grounds stated in the petition, learned counsel for the respondent number 1 does not opposes the prayer for condonation, condoning the delay. Stop. In view of the fact that the learned counsel for the respondent number 1 has not opposed the prayer for condoning the delay, as well as in view of the fact that the grounds shown in the application by the applicant for approaching this court beyond the period of limitation, beyond the prescribed period of limitation, is found to be sufficient ground, the delay of 63 days in preferring the connected MSc appeal is hereby condoned, and this interlocutory application is accordingly allowed. Registry is directed to register the connected MAC appeal and list the same for admission on a date to be fixed by it.
Next week, Lordship.
No,
Next week, any date. Next week, any date.
in the next week, on a date to be fixed by it. List according, this case is accordingly this IA is accordingly disposed.
39 and 40.
None has appeared for the applicant on call. Is this matter again on a date to be fixed by registry.
41.
delay of condemnation petition, 247 days.
Also, in this case, I am appearing for respondent one, I am paying 2 week time for filing objection.
Heard Mr. A. R. Agarwal, a learned counsel for the applicant. Also heard Mr. Your name is reflected,
KK Bhutto.
K. Bhutto. Learned counsel for respondent number one, who prays for allowing him to file a written objection against the prayer made by the applicant. The prayer is allowed. He may file written objection before the next date fixed. Let this matter be listed after 3 weeks on a date to be fixed by the district.
42.
Here the service is complete, Lordship, and LCR will be received.
Heard Mr. S. P. Sharma, learned counsel for the appellant. Office note dated 11/8/2025 shows that notice issued to respondent number two through usual process has been duly served. The notices issued to all the respondents are accordingly duly served. Let this case be listed for admission.
What is the matter? already
Matter is admitted, na? Records have. It also appears that the records of the trial court have also been received. Accordingly, let this matter be listed for hearing after 3 weeks. On it. After 4 weeks on a date to be fixed by the district.
43.
May I please, Raja? Services awaited.
Heard Mr.
DZMD.
Heard Mr. What is your name?
DZMD. My name is
DJ
Methi.
Medhi, learned counsel for the petitioner. On perusal of the office note dated 23/7/2025, it appears that the notices issued to the sole respondent have not yet returned. We will await, or you will take fresh steps.
I'm permitted to take the steps.
Fresh steps. No, before that, when have you taken steps?
39/2024.
No, fresh steps. The petitioner is directed to take fresh steps for issuance of notice upon the respondent by registered post with AD, as well as by usual mode, within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Achieve interim order, maybe.
The interim order shall continue till next day. Fixed at to Keneke Kosil by mentioning all of Pisutli.
44. In this case, I have filed IA to 99/7/25 for directing the registry to release the 50% amount deposited.
ISO.
I am for the respondent number one claiming. The insurance company has deposited 50% of the
What
awarded amount.
happened during Lok Adalat?
Just not settled.
Huh?
Not settled.
But no order has been passed.
Okay. Basically, the insurance company.
You have any objection?
Getting 50%.
Heard. Mr. S. Islam, I heard Mr. S. Islam, learned counsel for the applicant. Also heard Mr. K. Bhatta, learned counsel for the respondent insurance company. This application has been filed. This interlocutory application has been filed by the applicant, claimant, who applicant claimants who are the respondent number
One,
1 and
only one. So. Injured person. The injured person, one.
Taizul and Muzammil
No,
Hussain.
that is another. It's the owner driver here.
Who is the respondent number 1 in the connected MAC appeal number 594/2024. की लिखी ली production from the very beginning. Praying for release of 50% of the awarded amount, which has been deposited by the insurance company before the registry of this court in pursuant to the directions of this court as a condition precedent for stay of execution of the judgment and award which has been impugned in the connected MAC appeal number 594/2024. Learned counsel for the respondent insurance company does not raise any objection to the said prayer. Hence, the prayer is allowed. Registry is directed to release the 50%, disburse the 50% of the awarded amount deposited by the opposite party, that is appellant insurance company, as a condition for stay of execution of the impugned judgment and award, to the petitioner, namely Muzammil
Hussain.
Muzammil or Mal?
Muzammil Hussain.
Muzammil.
M-O-Z-A-M-M-E-L.
Huh?
Muzammil, M-M-E-L.
E or A?
E.
Muzammil Hussain, after proper verification. This interlocutory application is accordingly disposed of. The main case,
PCR has received.
in the main case, write the names of the parties. Service is not complete. R2. Respondent number 2. In the main case, party Lekhar Pisa. On perusal of the office note dated 4/9/2025, it appears that notice issued to respondent number 2 has been received back without service with an endorsement not known in pursuant to the, no, it's not known, stop. In view of the same, comma, the appellant is directed to take fresh steps for issuance of notice upon the respondent by speed post within 7 days from the date of this order, returnable after 4 weeks, list according.
Public. Item 22.
Let me zero. In appeal against the judgment and decree dated 10/7/2021, whereby the judgment and decree dated 31/3/2021 has been affirmed. And so far, the result of the suit was concerned, the courts below have dismissed the claim of the present appellants. Now, my lord, substantial question is the question of law is at page, my lord, 6. Page 6. Now, number 1, whether the learned first appellate court has committed wrong in applying section 92 of BSA for admitting exhibit Q and exhibit G, which are the root of the title of respondents without the same being proved under section 60 of BSA, and that too.
This is not substantial question. This is not a substantial question.
So far the proof of document is concerned,
This involves questions of fact.
I am hearing something before logic, that whether a document, mere production of a document gets automatically proved unless the provision of section 65 original act has been complied with.
That is not a substantial question. It is a settled law.
When, my lord, the learned trial courts below has, my lord, deviated from the settled law, it becomes, my lord.
It becomes what?
My lord, so far that part is concerned, my lord. When the learned courts below has, my lord, decided that particular issue in contradiction with the earlier findings, purpose, my lord, so far second part is concerned. And so far the proof of the document, which is the root of the, my lord, the defendant's claim, my lord, that has not been, my lord, in conformity with law. That is,
Then
before your lordship, that has to be in conformity with law. I am submitting before lordship that my claim has been denied, and they have
wrong
accepted-
application of law.
Yes, my lord.
What is the result? Result, is it a perversity or it
Yes,
became?
sir. So far the perversity part is concerned, the second question of law is the perversity. That relates to, my lord, issue number 2 and issue number 3, my lord. How, my lord, it is perverse, my lord, I am submitting before lordship that my claim, that is the original, my lord, plaintiff's claim was that the schedule Kholan is the part of the schedule A land, was mortgaged to the beneficiary interest of the defendants in the year 1970.
No, we are not going into facts. now.
No, madam, I am submitting that what perversity that both the courts will has committed as regards to, my lord, findings, my lord, my claim. But so far the issue number 2 is concerned, what the learned courts, both the learned courts will have decided that so far the mortgage part is concerned, it was not a mortgage, my lord. Because that mortgage was oral one, it was not writing, so section 59 of TP Act, it ought to have been, my lord, in writing, and that ought to have been, my lord, registered under section 17 of Registration Act. But subsequently in, my lord, while deciding the
Now
issue number
you
3,
come one by one.
Right.
Which is your first?
the first one is, my lord, one was the first, my lord. Serial number 1.
Read it.
Yes. Whether the learned first appellate court below has committed wrong in applying section 92 of BSA for admitting exhibit Q and exhibit Go, which are the root of the title of restaurant without the same being proved under section 60 of BSA, and that too discarding the operation of section 109 of BSA. 109 is the original 106 of Evidence Act. Now, section 60 is the 65. Original 65. Section 65. The procedure has been laid by the said provision how to prove a document.
Wrong application of law
Yes,
by the trial court
yes.
can be rectified at the stage of
Non,
First-
non-application, non-application. Non-application is also there, so for the discarding the operation of section 109.
you have any judgment in your support that non-application becomes a substantial question of law, or that it can be looked into in the second appellate stage.
So for other parties also concerned. Then my lord. One
Your
party-
submission is that law was not properly applied.
one row.
Law,
Discarded.
law was not applied,
Law was my lord.
not followed.
Law was my lord not followed in respect of one part, and in another part that was discarded.
Discarded means
Discarded means that operation, that is so, one of the facts is such, may I submit to also. I am submitting before the trial court below that a particular property has been mortgaged. Now they are claiming that no, that was not mortgaged, that was sold to us. So their claim, right of possession, they have claimed that it was based on.
now whether
certificate.
it was mortgage or whether it was sold, these are question of fact.
That's too much. I am
So
not
you
aware.
have come across two courts, trial court as well as
So far,
which can,
what
which,
the courts below has committed wrong, I am not pointing out. The when a person has. claimed
all
that-
wrongs committed by courts below, can it be looked into at?
Not all. This is so far that the proof of a particular doing, which is the root, my lord. Basing on which they are claiming, it is their duty to prove it in accordance with law. my
No,
lord.
you come up with authorities to support your submission. Otherwise, heard Mr.
I'm patient.
M.K. Sharma, learned counsel for the appellant, who prays for some time to produce authorities in support of his submission that this case, this appeal involves substantial question of law as proposed by the appellant in the memo of appeal. The prayer is allowed. Let this matter be listed when? In the next week. In the next week on a date to be fixed by this.
All right.
My lord, I beg your pardon me, lord. In the morning, I mentioned one item, item number 52. But I forgot to, my lord, pray before lordship to, because the stay order is till today, till the date of next listing. So kindly be extended till, my lord, next date of listing, my lord. Item number 52.
You have informed the other side.
I also said, yes, my lord, yesterday we talked.
Abhishek, item number 52, the interim order shall continue. Huh? Already signed. So you to change করে দিব. The interim order shall continue till next day.
Next day. Obliged.
Yes, given item. Item number 45. Yes,
Small note, from record it is seen that the notice have been, they have received the notice. One, two, four. 1, 2, 3, and 4 have received the notice. And the 5, my lord, AD has not come.
what is to be done? Five.
We will take steps again for 5.
Okay.
But now,
Ah.
now my submission is there, my lord. Kindly see the first order passed by the High Court on 19/5/25. My
Yes,
lord. My lord, heard Mr. Soikia. In this petition, under Article 226 of the Constitution of India, the petitioner have put to challenge the correctness or authority of the order dated 21/25 passed by the learned civil judge, junior division number 4, Tamruk, Guwahati in which case number so and so, in arising of title suit number so. There is the petition as well as the documents placed on the record, and here also there is the order dated 21/25. Let notice be issued to the respondents within a week. Registry shall call for the record. The records might have found the records has come, but the title suit record have not been sent by the trial court. Because we have challenged the Mish case arising of title suit. Both the records should be sent, my lord.
What is the stages? Who are you? Defendant.
I am defending.
Therefore, you are interested in calling for
But
title
because
suit.
records should be necessary, and because in the records it was seen what happens in the real case. So the court called for the kindly see, my lord.
Miss case.
Registry shall call for the record.
No, no. What you are challenging in this?
I have challenged the order passed by the my lord.
Order of?
In the Mish case.
Order of injunction.
Yes, order of for dismissal of the suit. Because under
Suit has
order-
been dismissed.
this, yes, order 7, rule 11.
Okay.
But they have challenged the order of the revenue board. So that the order of the circular officer and the DC, that should even appeal before the board of revenue. I have brought the judgment. There are a good number of judgments passed by the High
So
Court.
then the title suit is no longer pending.
That is there, she, trial court, she is taking the title suit. My junior is attending the court. In spite of the order passed by the High Court.
Your prayer was for
calling for the-
rejection of plaint.
Yes, for fair to dismiss the suit, main case.
On what ground?
That I have filed a petition under order 7, rule 11, that the suit is not maintainable because they have challenged the order of the circle officer. And my lord, under the law.
Okay. We are not calling for the original record of the title
No, my
suit.
lord,
We will call for the scan copies.
my lord,
We will call for the scan copies, Mr. Saikya.
may call for,
Heard Mr. R.C. Saikya, London. Senior counsel assisted by Mr. J.P. Barua, London counsel for the petitioners. On perusal of the office note dated 5/9/2025, it appears that notice issued to respondent number 1 to 4 have been duly served. Stop. However, the notice issued to respondent number 5 has returned without due service. The petitioner is directed to take fresh steps for issuance of notice upon respondent by registered post with ID as well as by usual, no, continue.
5, my lord. Notice is number 5.
Petitioner is directed to take fresh steps for issuance of notice on respondent number 5
5.
by speed post within 7 days from the date of this order,
Yes.
returnable after 4 weeks. Learned senior counsel for the petitioner also submits that though the records of the trial court was called for, however, only the records of Ms. J case number 47457/2022 has been received, and the records of title suit number 86/2022 have not been received. Stop. Since the title suit number 86/2022 is pending before the Court of London, Civil Judge Junior Division number 4, the original record need not to be called for. However, the scanned copy of the records of title suit number 86/2022 be called for. The registry to issue requisition for calling the scanned copy of the aforesaid records. List accordingly.
My lord, just a minute. Procedure order of the first order, interim prayer will be considered. So my lord, my interim prayer, my lord, kindly see the petition for a while. What is the interim prayer? Page number, my lord. page 18 of the CRP. Kindly see me. Page 18. And the page 19, bottom portion.
Let 5 appear.
In the interim, pending disposal of the civil petition, as the imbalance has existed, further proceeding in the title suit number 86 of 22 pending before the Larned Civil Judge Senior Division 4, may kindly be stayed. That should be stayed. Or if that should proceeded, what will be the purpose of filing this case? That's the one that the
But the observation was interim pair would be considered only on appearance of the.
No, but they did not appear. What is the, how
But
can you help?
notice is yet to be served on respondent number 5.
My lord, that respondent 5 is actually not an important party. 1 to 4 is important. They notice
No,
was served, but they are not appearing
Let the notice be served on respondent number 5.
to 5. Why again we will take step for 1 to 4, my lord? Notice is served already. 1 to 4, notice is properly served.
You have not heard while I was dictating. There is no direction for issuance of notice on 1 to 4.
My lord,
Only against 5 you have to take fresh step.
I will take, but that interim plan may be considered to them. my lord.
After appearance of respondent number 5. due-
My lord, if this shoot is going on, then it will be, this appeal will be, this division will be infectious.
No, it will not become infractual.
No, that may be stayed, my lord. Division. That, my lord, that
Let
is
the other side appear.
with my lord, it's on 5.
5. Let after due service of notice on respondent number 5.
Will let it be sent by the dusty service. We'll send the dusty service.
Learned senior counsel for the petitioner submits that the petitioner may also be allowed to take steps in addition to
Speed post.
speed post by way of dusty mode to issue notice on respondent number 5.
Aye.
The prayer is allowed. If the notices are served by dusty mode, the petitioner shall file an affidavit of compliance
Yes,
on the next date fixed.
oblige. Oblige. Actually, I am sorry that your lordship is passing the order very nicely, but I could not hear. All
46 and 47.
oblige.
Let me get it. This case by the earlier order, dated 27/6/2025. The observation was made for consideration of the interim prayer on appearance of the respondent. Now, office note dated 14/10/2025.
No, what for this CRPIO is filed?
My lord, it's a decree of my lord 2017 filed by the my lord daughter under section 23 of the my lord, Hindu Adoption and Maintenance Act against the father. Father is the respondent number 1 here.
23. Section 23 is for
23.
maintenance.
Maintenance was that order was passed. Then
You are father,
I'm the daughter,
your daughter, the other side is your father.
father. He is representing Oil India Limited. I am the employee. He is Oil India Limited.
Okay.
The petitioner, perhaps he is representing the respondent number 1 in item 47. Now, under this decree of 2017, my lord, I have my lord, filed an
You're
application.
taking up item number 46 first.
Yes,
46.
46 service not completed in respect to respondent 1.
My lord, it is in a way, my lord, complete.
No,
in the sense that
46 why this CRP has been filed? 46.
46
What grievance?
My grievance is that, my lord, that's what, my lord, the decree of, my lord, the order of 2017 for maintenance of direction was issued by the court, my lord, to pay the maintenance, etc. That was not paid, so I have filed an execution case. There, the respondent number 1, the father had appeared, and he committed that, yes, this amount will be there, will be paying that. This is observation is there, and thereafter he abandoned the, my lord, the execution proceeding. The father did not appear. I have filed an application, my lord, for attachment of the amount which was lying. The father was the employee of the Oil India Limited. He was to receive the salary, etc., some other dues. So that application was filed.
but then the court below has taking view that the other section 60G of CPC, the pensionary benefit, etc., cannot be annexed, and thereby that order has been rejected. That application was rejected. Then this amount was to be coming to the HDFC Bank. So I have again filed an application. The direction may be issued to the bank to hold the amount in the bank, so that
That amount is pensionary benefit.
it includes everything, my lord. It is salary component, pensionary benefit, plus other dues as well. So that petition was also rejected, saying that in the earlier occasion, because of the section, the 60, the G, having been already rejected, so accordingly that has also been rejected. So I am challenging both these orders before this court, that this maintenance amount is not covered by the section 60G method, because it is a pension fund. The Pension Act is not applicable. He is an employee of the Oil India Limited.
PG.
Section 60 subclause G. Stipends and gratuity allowed to pensioner of the government or of a local authority or of any other employer, or payable out of any service family pension fund notified. So this is family pension fund notified. And this family pension, my lord, it is not pension, it is family pension fund, which is also meant for the, my lord, the family members. So they are not precluded from, my lord, attachment of this property at their behest under section 60G, my lord. And in fact, my lord, in an earlier, my lord, occasion, your lordship will kindly consider my mother had filed an application under the, my lord, Domestic Violation Act, my lord, section 12. And there also an order was passed for maintenance. And that amount, my lord, having not been, my lord, paid, similar petitions were filed. In the meantime, my lord, the proceedings, the father had approached this court because he was in the meantime terminated. Then the mother had filed an application that she is entitled to this much of amount. The Oil India also said, yes, we have received the summons from the court that this amount has to be retained. So therefore, after this order, this court, after considering all the matters, directed that Oil India Limited to remit the decretal amount so far as mother is concerned to the account of the mother. And so far the other amount is concerned, that was to the respondent number 1. There was no objection from any of the side, whether it is a pension amount, whether it is a blood fraud. Nothing was objection. So therefore, my lord, if at all, my lord, they are debarred from, my lord, due to application of section 60G, if this cannot be attached, also that particular, my lord, legal right they have already waived. And now whole crux is that the father had appeared. So we'll kindly see, my lord, the page 33. It is basically, my lord, maintenance amounts to the daughter, my lord.
Page 33.
Page 33, order dated 18/1/2023. Decree holder is represented, order of the Honorable Supreme Court, my lord. Against this order, they have preferred a, my lord, revision petition before this court. My lord, with regard to the maintenance granted by the court, they have, my lord, approached by a revision petition that
Maintenance granted to whom? Daughter or mother?
the daughter.
How many daughters?
One.
Okay, to the daughter.
Against this, my lord, this order dated 6/6/2017, which is at page 19. They have challenged, preferred a civil revision petition that was dismissed. They have went to the Supreme Court, my lord, that was also dismissed. Decree holder is represented, order of the Honorable Supreme Court in essay number so-and-so has not been filed as directed earlier by the order date. However, from the website of the Honorable Supreme Court of India, order dated so-and-so has been retrieved, which shows that SLS Civil so-and-so was dismissed by the Honorable Supreme Court of India by holding that there was no ground to interfere with the Imperial Order 12/2000 passed by the Honorable Guwahati High Court in Civil Division Petition number 18/9 of 2018. In view of the above, since the order dated 1/2/2009 shows that notice was duly served on the JD and report received by the service, it is seen that JD is well aware of the present execution proceeding. By petition number so-and-so dated so-and-so, it was placed on record that terminal benefit of Dr. Deepak Kumar Gogoi, employee number so-and-so, was lying with the Oil India Limited, and hence the said authority may be directed to satisfy with the decretal amount. Also on record, one letter dated 19/7/21 issued by Dr. Deepak Kumar Gogoi to the decree holder, wherein the JD has admitted monetary obligation of 59,70,000 as on the said date towards the decree holder, and further stated that Oil Duliajan has sanctioned rupees so-and-so towards his terminal dues, which as per the said letter has not been released in view of the bar imposed by the courts. In the said letter, JD is seen to have proposed to divide the dues into equal one half to the Shivangi Gogoi, that is the present petitioner, and Rustaf, and the other second half is proposed to retain for herself. Since the aforesaid letter was by way of a settlement offer Dr. Deepak Kumar Gogoi and his wife and children, it is not known what transpires thereafter. It is also placed on record that the balance standing in the credit of Deepak Kumar Gogoi as on 17/3/2020 was 98 lakhs so-and-so, as would reflect from the letter number so-and-so placed on record by decree holder. In view of the above, this court deemed it appropriate to issue notice to the judgment debtor Deepak Gogoi, directing him to deposit the decretal amount on or before the next date fixed. In this court, decree holder to take step issuance of so-and-so, so-and-so. Then thereafter, my lord, the Deepak, well, this respondent number did not appear. So, my lord, therefore, my lord, I have to file the petition, my lord. At page, my lord, this petition I have filed, my lord, at page 69, my lord. The prayer your lordship will find, my lord, 73. It is therefore prayed that your honor may be in interest of justice be graciously pleased to issue direction to Oil Duliajan to satisfy the decretal amount to rupees 30 lakhs so-and-so by deducting the same from the benefit due to the judgment debtor, and to pay to the decree holder and holder the sum of rupees 30,75,000 in satisfaction of the decree in the instant money execution case number 1 of 2018. Now, my lord, the order came to be passed on 5/6/2024 at page 76. 11 page 77, lordship may come to my lord, page 78. Paragraph 5.
Yes.
Heard learned counsel for the decree holder as well as the peruse the record and the documents submitted by the decree holder, and careful perusal the provision of CPC in conducting a money execution case after going through section 60 of CPC, read with order 21 rule 30 of CPC, I find that this petition is not maintainable, as under section 61G of CPC, stipend of gratuity amount to pensioner of the government or local authority or of any other employer or payable out of any service family pension fund notified in the official gazette by the central government or the state government in this behalf, and political pencil, etc. So and so. Accordingly, this has been dismissed. Now, my lord, he had approached this court, the father. Initially, his bank account was at the State Bank. He wanted his salary as well as the other pensionary benefit to be remitted to a new account of HDFC Bank. That order has been passed by this honorable court. While passing that order, due note was taken so far as the my mother's decree was concerned under this Domestic Violation Act. And that amount was directed, this court directed the Oil India to retain and to for the satisfaction of the decree. Accordingly, that decree has been satisfied. Lordship will kindly find that order, my lord. Page 60.
No, but this order declining your prayer to
But
was passed because of a statutory bar.
my lord,
How will you overcome that statutory
yes, my
bar?
lord. First of all, my lord, I'll come to that, my lord. This pensionary fund, my lord, it is not the, my lord, personal pension of the person concerned. This is a family pension fund, the word used. My lord. So this family pension fund meant for the family members. So they cannot be precluded from, my lord, enjoyment of that fund. This is number one, my lord. And secondly, with regard to the satisfaction of my mother's decree, they did not raise any objection. That order, your lordship will kindly find, my lord, page 60.
No. Assuming that they did not raise objection
That-
at the time of releasing fund in favor of his wife. But that was a statutory provision. It cannot be waived.
Statutory, but it's a legal right, my lord, that can be waived, my lord. It's not a, my lord.
You have some authorities.
Because therefore, my lord, this concept of waiver, etc., these are there, my lord. That I'll satisfy, my lord. Exact authority I have not got today. Because only the fundamental right that cannot be waived, etc. But so far as the legal right, one can always, my lord, waive. That is, my lord, this objection was not put by the father also. Neither the Oil India has any objection.
In this case or in earlier.
Even in this case, even in this case also, it is only the court of which own, my lord, has thought that under section 61G, there is a bar, so I will not be entertaining. Now, thereafter also, lordship will find I have filed another petition because as per this order of the High Court, the amount was to be, my lord, deposited to the HDFC Bank. So I have filed another petition. Your lordship will find is that petition at page 79.
Yes. What is this?
Here, lordship will find the prayer, my lord, at page 81. It is therefore prayed that your honor may, in the interest of justice, be graciously pleased to issue direction to HDFC Bank, Dulias and Branch to deduct whole the decretal amount of rupees 32 lakhs 50,000 from the amount of the judgment debtor 2020. So this is a direction to the HDFC Bank. This is this amount. This is money. It is not pensionary benefit or etc. whatever, my lord, but it is a money. So this money is liable to be attachment under section 60 itself. Section 60, my lord, if I am read, my lord. The following property is liable to be attachment and sale in execution of a decree, namely lands, house or other buildings, goods, money, bank notes, exchange of bill, etc. etc. So these are liable to be.
No, read completely.
Section 60, my lord.
Yes, section 60.
One.
One and the clause G.
No, now I am on the one, my lord.
Okay. Read.
G, these are after the proviso, my lord. First, my lord,
Yes, please read.
the following property is liable to attachment and sale in execution of a decree, namely lands, houses or other buildings, goods, money, bank notes, check, bill of exchange, handis, promissory notes, government securities, bond or other securities for money, debts, share in corporation and save as hereinafter mentioned, and other saleable property, movable or immovable, belonging to the judgment debtor, or over which or the profit of which he has a disposing power, which he may exercise for his own benefit, whether the same be held in the name of the judgment debtor or by another person in trust for him or on his behalf, provided that following particulars shall not be liable to such attachment of sale of money. Then comes, my lord, the subsection G. So first, principal section 1, my lord, the money is attachable. Now bank is holding the money. My prayer is for direction to the bank to hold the amount or to retain the amount for the purpose of satisfaction. But the court has passed the order, you will find, my lord. Page 87. So long order, Lordship may directly come to the. Page 90, paragraph 7.
Yes.
Paragraph 7. After perusal of the submissions of the learned counsel for the decree holder as well as the written submission, I find that this court has already decided this matter by order dated 5/6/2024, and same cannot be decided again by this court. Because of the earlier order, my prayer for attachment or the retainment of the amount lying with the employer, that was rejected. So therefore, the amount which has been remitted to the bank or likely to be remitted to that account, according to the court, that it is comes the principle of res judicata, etc. But this is a totally two different concepts. One is the money, another is the pensionary fund. I'll satisfy your lordship regarding the pensionary fund also. But independent of that finding, my lord, I'm saying that the amount that is lying with the bank.
Why this matter has been listed in orders column today?
My lord, this is the order dated 27.
Respondent number 1, service upon a respondent 1.
Service upon the respondent number
Who
1.
is respondent number 1?
My lord, he is not appearing here.
He is the main person.
Yes.
He is absent, but then my lord, the contempt, my lord, he is the same person who is, my lord, preparing the item number 47. He can accept the notice, my lord, and
No instruction to appear in the case and.
he can obtain the instruction. That is one thing, my lord, but then this is an avoidance what has been, my lord, sought for. Therefore, my lord, this contempt.
No, but service notice can be served on them.
My lord, lordship will kindly see, my lord, the
This contempt is in respect of what?
this contempt is in respect of non-remittance of the amount to the HDFC Bank. If I'm
By
not wrong.
Oil India.
Yes.
No, by Oil India. So this contempt is against the officials of Oil India Limited filed by him. Once this amount goes, in fact, on the last occasion, while on 27/6, although the effective order was not passed, but then this court has instructed the counsel for the Oil India not to disburse the amount.
But difficulty is that, lordship, before that order passed, already all the pensionary benefit has been released. Lordship.
Thing is that, my lord,
All before that order passed, lordship. Because this repetition, lordship may kindly appreciate that earlier order was passed on 5/6/2024, and thereafter they sought several times to file appeal, lordship. And pursuant to the only in the year 2025, they have filed similar type of petition, which has been also denied, lordship. And in the meantime, before this petition CRP was moved, lordship, already amount was already released, except the amount, because if lordship come to page 92.
Yes.
That and due to the judgment declaration, along with breakup of the oil authority is also directed to hold the payment up to rupees 32,75,000 from the part of wages. And
What is
benefit.
this money?
Lordship.
32 lakhs.
Yes, lordship, I am coming to this. What part of wages and benefits which are not part of the pension, lordship. So that means the wages, lordship. It comes within the definition of wages, leave encashment. So now already gratuity, pension, all are released, lordship. Only now oil has hold up rupees 19 lakhs because it's come. Okay.
Okay, in the CRP,
Yes.
notice has to be served.
My lord,
Because he is the main respondent, lordship. But I am
yes, my lord, so far as the office note goes, my lord, so far as registered post is concerned, my lord, it is said, my lord, it is not served, but then usual post, my lord, it is been served.
Served.
Yes, sir.
Then, okay,
Process
that
server-
is enough.
Process server report.
at flat showing similar, there's office note dated 14/10/2025. Received by an employee of the respondent. 14/10 office note.
No, but respondent number one is himself an employee.
He's already.
No, my lord, his address
retired.
is somewhere else. My lord, he has already retired from ONGC.
But the-
His now address is at Guwahati, I
Processor.
have given. Page 3. This is the same, what is the address of the contempt petition?
It has been received by some Yashoda Chetri. Who is this Yashoda Chetri?
Says by an employee of respondent.
Employee respondent is employee of respondent means his personal employee.
So this is a residential address.
Then why the notice issued by registered post came with a report that no such person?
This process service always, the Supreme Court says the trouble starts only when a decree is passed.
No, but what is the way out? The engaged counsel is reluctant to accept notice on the ground that he has not been instructed. The
He obtained instruction and,
You-
my lord,
you-
and
you-
I
you-
have shown, my lord will see it, since 2017, a daughter is my lord, running pillar to post.
You-
to
you
get the
take
maintenance
instruction.
amount.
let him take instructions that otherwise this court may take some presumptions, not presumptions.
This has not been objected, my lord, this service by the employer. If he comes with the objection that he is not the employer, that time it will be considered, my lord, that otherwise service per se has been completed. So far as the usual course is concerned.
The company does not have any knowledge of CRP being applied. Only
Now you can take instruction. We will
Yeah.
issue.
Yes.
Came to know that.
Yes, that may be, that may be. He can take instruction.
Take it. The whole thing, my lord, the amount since 2017, my lord, now is a. And because of his non-appearance. This judgment order, my lord, that's assailed in CRP, assailed in Supreme Court, all have been rejected. And then he has.
Now, will you take fresh steps by speed post? In the meanwhile, let him take instruction also. We will not pass any orders regarding usual mode, whether it is to be accepted or not. On next date, we will pass as regards service of notice. Because the report of processor was says that she is the maid or household employee.
My submission is that this service has not been challenged till now by him. My lord.
No, before he challenges, court
Okay.
must come to a,
Yes, my lord, I can take speed post, I can take. And in the meantime, my lord, he can also, my lord, obtain instructions.
Yes.
That observation lordship can give because the
Yes.
person is same, cases are relating to the same issue.
yes. Heard Mr. P.J. Soikia. learned senior counsel assisted by Mr. A.K. Gupta, learned counsel for the petitioner. Also Mr. A. Sharma,
K. Kolita, Lordship.
K. Kolita,
And put a respondent to
learned, you are standing counsel.
No.
Learned counsel for respondent number 2. Also Mr. And stop. On perusal of the office note dated 14/10/2025, it appears that notices issued to the respondent number 1 by registered post with ID has returned without service with an endorsement on the envelope within bracket, within inverted comma, addressee left or no such person. Stop. RTS. However, the notice sent to the respondent number 1 through usual mode, that is by through process server, has returned with with a report of the process server that the notice that as the respondent number 1 was not found in his residence, the notice was served on one Yashoda Chetri, who claimed herself to be an household employee of the respondent number 1. Stop. Learned senior counsel for the petitioner has further submitted that in the connected contempt case, that is contempt case number 199/2025, the respondent number 1 is the petitioner, and he has been represented by his engaged counsel, Mr. H. Agarwal, who can very well receive notice on behalf of he can also receive notice.
provided he is instructed by him.
No. One is after taking instruction, or is the engaged counsel of the respondent number of that person for some other case.
Directly on this, he may not be, without instruction, he may have difficulty in accepting.
Okay,
He may obtain that.
stop. No, last line too.
The chief may observe that the addresses are.
No. A line to continue. Stop. On a specific, Mr. H. Agarwal, who is present in the court, was posed a specific query as to whether he may receive notice in CRPIO number 238/2025 for the respondent number 1, Dr. Deepak Kumar Gogoi, full stop. On this, learned counsel, Mr. H. Agarwal, learned counsel for the petitioner in contempt case number 199/2025 submits that he does not have any instruction to appear for respondent number 1 in the instant civil revision petition. However, civil revision petition stop. The learned counsel, Mr. H. Agarwal, is requested to take instructions in this regard as to whether he can accept notice in notice for respondent number 1 in CRPIO number 238/2025. Stop. In the meanwhile, the petitioner is directed to take fresh steps for issuance of notice by speed post on respondent number 1 within how many days?
3 days.
Within 3 days from the date of this order, returnable on
First week of November.
returnable
On 12/11.
returnable on 13th of November. 13th of November. List accordingly.
I may also serve a copy for onwards submission to him, my lord, the council.
Yes.
Copy has been served.
In case we get the instruction to appear in this case,
There'll be-
kindly Wakalat and appear in the next.
Okay. Otherwise, we have not made any observation regarding service of notice through usual mode. That is kept open.
That's
We'll pass orders as regards that on the next day. And regarding contempt matter,
That was, in fact, I have paid before the court to kind of bring along with this, no effective order perhaps is to be passed. It is only for this purpose, this matter was, contempt matter was called.
And it may be listed before the appropriate bench, so far as the contempt matter is concerned.
No, that.
Now, since he has been instructed. yes.
No, that may be retained along with this because next day otherwise.
Then
we-
next day.
this is contempt of an order passed in a
Writ
writ petition. Then how this,
Bench
could-
three,
then it has to go before appropriate bench.
I'll inform him, whenever my matter is listed, I'll inform.
Yes.
13 to 8 is.
Heard Mr. H. Agarwal, learned counsel for the petitioner. Also heard Mr. K. Gogoi,
B go,
B. Gogoi,
for the sole response.
learned you are
My lord, the engaged counsel, otherwise I'm the standing counsel for oil, my lord, but contempt case, my lord, I will be appearing as a counsel for the response.
learned counsel appearing for the sole respondent. It appears that this matter pertains to which bench?
Bench three, my lord, civil bench three.
Civil bench 3.
Well.
Therefore, registry is directed to list this matter before appropriate bench.
So far as CRP is concerned, may I further pray, as the council has said, 19 lakhs and all this lying, at least that much to retain.
Already written because there is a.
That is an order.
Order.
An order is there.
Alright,
So further
order-
order.
it comes with the order.
In this case, your main plea is that the statutory bar of 60 is not applicable to.
Family pension.
But
Yeah.
difficulty is that already amount has been released.
Okay.
Pensionable amount has been released, except the 19 lakhs.
Ultimately.
Let him appear.
That's him. Lordship has seen around 18, the father has said, yes, I am having a 75 lakhs or so, so I'll be distributing among both the son and daughter. And then thereafter he has abandoned the person. So once he appears, if he undertakes to pay certain amount even in installment, that will satisfy the entire things.
Okay.
Item 48.
Lordship, as per office note dated 13/10, TCR has come, Lordship. But step that he has supplied before the registry, Lordship, that could not be sent because some pages were stated to be illegible, Lordship. We will file press copies, Lordship. And in the meantime, Lordship, the interim may continue, Lordship. In the IA, there is interim order.
Fresh copies for what could not be sent?
Lordship, the copies that we have supplied are stated to be illegible. Few copies are stated to be illegible, Lordship. So we will furnish fresh copies, Lordship.
Copies of what?
Copies of our
Notice,
our
petition.
notice, Lordship.
Okay. Heard Mr. A.J. Soikia, learned counsel for the appellant. On perusal of the office note dated 13/10/2025, it appears that the records of the MSC case number
1/22, Lordship.
1/22 has been received from the concerned motor accident claims tribunal. Stop. However, it appears that the notices could not be issued to the respondent, as same were accompanied by copies of memo of appeal which were illegible. The petitioner, the appellant undertakes to furnish legible copies of the memo of appeal. Stop. On receipt of the legible copies of the memo of appeal, notices shall be again sent to the, how many respondents are there?
Lordship. Five, six, Lordship.
To the respondents
Six respondents. Lordship.
with returnable date as 25th of November. The interim order shall continue till next day.
Okay.
May I please, my lord, this matter also should have come under motion matter, is a fresh matter, but unfortunately it has come under orders. Can it take it? It's a delay IA for delay condemnation of 2 days. Because for the health reason, the respondent, petitioner number 1, applicant number 1,
Mr. What is your name?
SS Ahmed, my lord.
SS Ahmed, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed by the petitioners praying for condoning the delay of
0 2 days.
2 days in filing the connected civil revision petition, whereby the petitioners have impugned the order dated 26/2025 passed by learned civil judge junior division, Shankar Dev Nagar, Hojai, in Ms. J case number 105/2024, arising out of title suit number 105/2024. Stop. Issue notice to the respondents. How many respondents are there? Only one. Issue notice to
Only
the
one, my lord.
respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with ID. By speed post. By speed post within 7 days from the date of this order, returnable after 4 weeks. List according.
Oh, bless you.
Item 53 from supplementary list.
May it please, madam. My lord, already the service is complete, my lord. This has been wrongly listed. Let it come for admission hearing now. On 27.
Heard Mr.
A. Iqbal.
A. Iqbal, learned counsel for the petitioner. Also heard Mr. K.K. Bhattacharya.
I'm appearing for the respondents 7 and 8, the state respondents, state of Assam.
Learned government advocate appearing for state respondent number 7 and 8. It is submitted at bar that this case has, in this case, service upon all the respondents is complete. And this case ought to have been listed in admission column. Is it right submission?
As per order dated 16/7.
Okay.
My lord, this service thing, it has been going on from that, my lord should know, from 26/6/25. So there is
In
some
fact, the
problem
respon-
since then, my lord.
Respondents have filed objection also.
So service is complete. Okay. Let this matter be listed in admission column when
27th.
on 27th of November, 27th of October.
Briefly, Your Grace.
Item 51.
We don't have time for hearing.
Lordship, but Lordship, we have, in this case, we have filed three IA. One is delay and abatement and substitution, Lordship. Delay was 378 days.
Those IAs are there.
Lordship,
Then why this matter has come up for hearing
wrong
column? Item number?
Item 51.
Yes. Delay notices. Notice have been issued. Who is for the, you are appearing for respondents.
Yes, respondent number 1 and 2. Respondent 1 had died that we have informed them. And for the legalized, we haven't received any wakalatnama yet. So I think notice have to be.
No, legal heirs notice may not go. In this IA, who are the opposite parties? All are legal heirs.
My lord. 3 and 4.
So then notice will have to go to them. Heard, Mr. A.K. Sharma, what is your name?
H.J. Tamuli, my lord.
H.J. Tamuli, learned counsel for the applicant in IA number 3173. Also heard Miss S. Todi, learned counsel for respondent number 1.
I'm also appearing for 2.
Respondent number 2. Respondent number 2. Who submits that she has no instructions to appear for the legal heirs of the respondent number 1. Hence, let the notices be issued to opposite party number 1A to 1G. The applicant shall take steps for issuance of notice upon the said respondent by speed post within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Lord,
Obliged, Lord.
obliged, my lord.